Okay. All right. And this was at Madco on eCourse and Inkster? Okay. Okay. I can accept your plea. I will dismiss the retail fraud charge. The prosecutor says that there's a restitution amount of $160 that you've agreed to. All right. Are you working, ma'am? What do you do?
I have a tech service.
What kind of stuff?
That's,
Oh, taxes. I thought you said tech, like technology. Okay. All right. How do we avoid you since 23?
I've been blind for 2.5 years. And at first it was just, I couldn't see anything and I had to get an assistant and a caretaker.
So tell me that story. What caused you to lose your sight and then you got it back?
I got my lashes done. Woke up the next day. Mine was just not funny, but I have to laugh so I don't cry.
What was it, chemicals or what?
Yes, I have a disease called VKH in my system because of my Indian blood.
Never heard of that.
Yeah, it's rare. And the chemical in the glue that they chose to use that wasn't lash glue caused a reaction.
Okay. So how did you get better? Just had to get out of your system?
Once they figured out what the disease was, they got a plan of treatment. I have surgery in September. And so I will be able to see out my eyes, but the disease will still be in my blood.
Okay. All right. So you've got your vision is still impaired.
Yes, I can see like 2 lights outside of me, but I can hear your voice.
Okay. Okay. So you can't even tell how dashingly good looking I am?
No.
What a shame. Joe, get her phone, take a picture. So after the surgery, she. Okay. So when's the surgery scheduled?
Go to say to get the actual date.
Yeah. Good luck. Good luck. Good luck. Wow. What a story.
So I know, like, firstly, they owe me money, but that was why I knocked the stuff off the counter because I was just going to pick up my cousin and she was walking on the side of the road out of the trailer park.
Right.
Sidewalk or anything, and I gave them my money for gas, and there was no gas coming off the pump.
Right.
And he wouldn't give me my money back.
Yeah. So you got frustrated. Yeah. Yeah.
But okay.
All right. Let's see. And you've already posted bond money.
Yeah.
Let's see what we can do. All right, so on the file, including restitution, the total is $450. So I'm going to apply your bonds. I took the bond from the dismissed file, put it on this file. You're still going to owe us some money though, because we've got bond fees, and so it's going to be about 180 bucks will close you out. Can you do that today?
Yes.
All right, go on downstairs and see the cashiers. They'll figure it all out. Once again, good luck with your eyes. He certainly has that. You just walk away. Go downstairs to the cashier. Spirit. Yep. Oliphant. Good morning, counsel. Wonderful. Your appearance.
Rights of your staff, the legal sign, court justice, and speed 804.5. Attorney Rare, Attorney G. Clements, on happens to go in his presence.
Desmond Oliphant.
Thank you. Do you know if he filed an appearance? Because we don't have anything in the system yet.
It's my understanding, he did. I'm not certain, but if not, I'll check.
Just not on the ROA? Okay. In the computer, not on paper.
Okay.
All right. Would you waive formal reading so we can arraign?
Yes, sir.
All right, I'll enter a not guilty plea. Counsel, you got a radio voice. What are you doing? What are you doing this for?
I've heard that many times.
Well, maybe they're right. Maybe you should like branch out. Maybe a radio show that talks about the law.
Yeah.
All right. So what are we doing today?
Yes,
Adjourn date?
during the 18th of September, we all, I said, to council, we just need to start on this meeting.
Sure.
9,
Time.
9.
9 o'clock on 9/18, live here. And I'm assuming you're not going to talk me out of a personal bond for Mr. Oliphant? All right. Are you working?
Yes, sir.
Where do you work? How long you been there?
5 years.
All right. I'm going to put you on a personal bond, sir, with 3 conditions. First one's pretty obvious, stay out of trouble. Second one's really obvious, be here for court on September 18th. Third one, do not purchase, possess, or consume any mood altering substance unless you've got a doctor's prescription. Can you live with those rules?
Sir.
Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you mess up on bond? Any questions? Counsel, we good? We'll get you a paper notice before you leave. You're all set. Have a good day, gentlemen. Name?
Yep.
Yeah. What's the name?
Travel.
TR?
I am right-handed.
Mm-hmm. Nope, I don't have any tramels. Tatum? Rodney?
It's Jacoby.
No.
No.
I've seen that file. Because I remember Jacoby. Good. Oh, it's more. It's more.
It's more.
Yeah, tramel. Or hyphen. Awesome. She gave you the message. Mr. Moore, come on up. Are you going forward today without an attorney? All right, it says here that you're going to plead guilty to disorderly person and the prosecutor wants me to dismiss retail fraud. Did you read your rights form? The rights on the back of the sheet? Did you read those? You understand those rights? Understand the possible penalty for the charge? Understanding all of that, are you pleading guilty to that charge freely and voluntarily today? All right, on June 23, 2025, where were you at 3380 Wick and Vining?
Yes.
Was that at the Sheets store? Okay. And what happened there that makes you think you're guilty disorderly?
I really, to be honest, I really don't even remember everything. To be honest. I don't know, like, I got into like with the officer.
Were you drinking?
No,
Why don't you remember? You were high? All right. So I can't take a guilty plea because for a guilty plea, I need you to tell me what happened. But if you want to plead no contest, which means, Judge, I'm not fighting the charge, I can find the facts I need that support the plea because luckily the officer put notes in on the ticket and the notes tell me what happened. So from your standpoint, it doesn't matter because there's still going to be a sentencing, right? Follow me? But you don't have to make something up because you don't remember what happened. You follow me? All right. You want to plead no contest? All right. And it's okay if I look at the facts on the appearance ticket? All right. So I can accept your plea to the disorderly, and I'll dismiss the companion case of retail fraud. Mr. Moore, are you working?
Yes, sir, I'm sorry to, I'm on a road.
New job. Where were you working last job you had? Been a long time?
I was out of work.
All right. What kind of shift you working at Amazon? Do you know yet? What days do you know?
Wednesday, Thursday, Friday.
Anything else you want me to consider before I sentence you? All right, fines and costs on the file, $500. I'm ordering 2 days on the court work program as an alternative to jail. Can you pay the $5 today or do you need options?
So,
Can you pay the $500 today or do you need options?
that's how much the,
Fines and costs are $500.
so if it was, if because to be honest, I was bad at you. I'm filing books, sir.
You threatened to kill somebody. That's what the disorderly person was. So if you want to withdraw your plea, I'll let you withdraw your plea and you can go forward with both charges. It's up to you.
But
All right. So I'll send you downstairs. You can talk to them about your options and you can schedule the 2 days on the work program. You sure you don't want to withdraw your plea? You want to withdraw your plea? Would you also like to get the advice of an attorney? Mr. Graziani is going to talk to you as soon as he gets a chance.
thank you.
Counsel, I've got the file up here if you want to look at the plea offer. Christian Peters. Counsel, your appearance?
John Graziani, Penal Enforcement 387, appearing on behalf of, here's
Good morning.
my station here.
Christian first.
Is this a final pretrial with the complainant to appear?
That is correct, Judge. We certainly want to complain if there's another version in my client, and that can go in itself.
How about September 18?
Yes, Judge, that's fine.
Still at 9, Heather? 9 a.m. That's live. Ms. Peters, that works for you? All right.
Thanks, Judge.
You just have a seat. We'll get you a paper notice. Trying to call civil.
There's only Sandy and only Marie here today.
What's your extension? There.
225.
Hey, I can't get 227 to answer the phone for me. What I need is I need Sandy to call 225 whenever she gets a chance. No big rush. Yep, thanks. Andre Davis. Good morning, Mr. Davis. Mr. Davis, are you going forward today without court-appointed attorney? All right. You've read your rights. You understand those rights and the options they give you? All right. And is that her already? Excuse me, sir. You're all right. Just stay right where we're at. Hello. Hey, when you can, Judge Tosano's asking me to cover some of her docket Wednesday. Can you, let me know what my afternoon mediations look like as soon as you got a handle on that? No big rush. Thanks. All right. You understand your rights and the options they give you? All right. Says here you want to set this for a bench trial. You understand that this misdemeanor charge, you do have a right to a jury trial? You understand the difference between the two kinds of trials? All right. And you're waiving the jury so we can schedule a bench trial? All right. September 18th, 11 o'clock, Heather? We'll get you a notice to come back for that date. Any questions?
Officer mediator too on the side, right?
I don't know how the prosecutor would handle the trial without the officer. So I would expect the officer to be here. Nah,
I want to follow up planning about officer too.
you don't do that here though. That's at the PD.
Right.
Yeah. Yeah. And I'll do that. I'm going to enter a not guilty plea for you.
Yeah, license.
Okay. All right. Any questions? All right. Just have a seat. We'll get you a notice for that court date. Just right there. Yeah. It'll just be a minute. That my Wayne County Judge's luncheon's back to me.
No, I have it, I started.
Oh, I'm sorry. I meant sent. I thought it was in my inbox. I'm like, why is she sending that back? Walker? Mr. Walker, come on up. First name. We got more than one Walker up today, so I want to make sure. Good. You're going forward today without court-appointed attorney? Yeah, he needs, yeah, put that one back. Yeah. All right. You met with the prosecutor. If I'm reading this correctly, you're going to plead responsible to double parking, which is an added charge. You've agreed to pay fines at cost of $250. And then everything that was issued on July 3rd would be dismissed, right? Is that your deal? All right. Can you pay the $250 today, sir?
So, that's possible?
Yeah. When can you pay it all? Joe, your screen and calendar. Can you see the calendar over there? Yeah, well, you can walk over there. Yeah, go ahead. No, you can go.
So, see if I can pay the land, that's possible.
Yeah, I like Fridays, so let's go the 15th. You want to just pay it all by the 15th?
Yeah.
That's fine.
Yeah.
Because I'm assuming there's a line down there today. All right, so you're all set. $250 on or before the 15th. Have a great day. You're all set. It'll be in the computer waiting for you. If you don't pay it, then all these charges are back up and you're dealing with all of them.
I know this is weird, but when my pay, I come back.
Front counter. Come back here and pay it at the front counter. I'm putting the double parking on the B ticket.
That's the. Ben's back. I don't know.
Good. Oh,
This is Mr. Walker's.
Mr. Reeves, how are you today? Good. Are you going forward today without benefit of a court-appointed attorney? Did you read your rights form? Did you understand those rights and the options they give you? Do you also understand the possible penalty for no valid operator's license on person? Are you pleading guilty to that charge today freely and voluntarily? Did you drive a vehicle in Romulus on July 2nd, 2025 while your license was suspended, revoked, or denied? I'll accept your plea to that charge. I'll dismiss both original charges. What's the status of your license now, Mr. Reeves? What do you have to do? Do you know? Who do you owe money to?
Timber,
Are you working?
Yeah.
Where do you work?
First of all, man,
What do they do?
it's like but 4 parts, like probably
Okay. Full-time job? Good job? How long you been there? Okay, good. All right. Anything else you want me to consider before I sentence you? All right, fines and costs on the file, $500. I'm assessing 4 days in the court, on the court work program in lieu of jail. That means instead of jail. Can you pay the 5 today, or do you need to talk about your options?
so.
All right, I'm going to send you downstairs. Downstairs, they'll tell you all your different payment options. They'll also give you information about the work program so you can schedule those 4 days. Any questions? You're all set. Good luck with your license.
Thank you.
You're welcome. Mr. Watson, come on up. Mr. Watson, are you going forward today without benefit of a court-appointed attorney? Did you read your rights form today? You understand those rights? You understand the options they give you? Do you understand the possible penalty for the added charge of no valid operator license on person? Is that a yes?
Yes.
Understanding all of that, are you pleading guilty today to the added charge? Are you doing so freely and voluntarily? Did you drive a vehicle while your license was suspended, revoked, or denied in Romulus on July 3? I'll accept your plea. I'll dismiss the original charge. What's the status of your license now? What do you have to do to get it straight?
I believe you have to pay off, the no insurance fines that I got, because that's really all it is no insurance.
Okay,
That's really,
all right, where at, do you know?
I believe, I seen, it would say the 32nd.
Okay, okay.
It was the 34th. It was on,
We're 34th. Okay,
and it was one more right here.
okay, all right. Are you working?
Yes,
Where do you work?
right now I'm working at Amazon.
All right,
And I,
full-time, part-time? How long you been there?
I'll be here for about a year now.
Okay, all
And
right,
I have insurance and everything right now, but I'm still working on it.
okay, okay. How soon do you think you can get your license straight, get everything paid off?
Like ASAP, honestly.
Okay. If it was gonna save you money here, how soon? You can get them all paid off? You got the scratch to do it?
Cause I don't know exactly how much I owe,
Right,
but I do know I have like
okay.
one officer told me I had over $5,000 worth of tickets.
Wow,
And I don't really know how to look that up.
Right.
So I just gotta really go to the course and find that
All right.
out.
what days do you work at Amazon?
I work Monday, Tuesday, Wednesday, I'm off Thursday and Friday, and I work that on me.
Okay, all right, here's what I'm gonna do. Instead of jail time, I'm going to order that you do 4 days on the work program. You pick the days, we'll give you a schedule. The days that you're scheduled, you have to show up that day. So 4 days work program. I'm going to charge you $500. Or show me that you've got your license renewed. All right. So I'm literally going to pay you $500 to go get your license.
Okay.
Okay? That's it. No, thank you so much. That's the greatest gift anybody's ever given me.
So much like, I don't know how.
So you understand where we're at?
Yes.
I'm going to give you 30 days to either pay us $500 or come back here and show us you got a license. All right? Go downstairs and schedule your work days. Good luck.
Thank you.
You're welcome. Okay. Mr. Moore, you're back. Come on up.
John Graziani, appearing on behalf of Jacoby Moore. Mr. Moore, can you please identify yourself? Judge, Mr. Moore wants a trial. However, I'm asking for a final pre-trial. It appears that I'm on AC and this gentleman is on DC. and
Okay.
I would like him to get some.
Okay. All right. So he's suggesting I give you a pretrial date instead of going right to trial. So on the pretrial, the next pretrial date, you can talk to another attorney and see if you got a better vibe. All right.
Gives us time in case it doesn't.
Yeah. Yeah.
That'll be our last day.
How about September 4th? What time? 9 o'clock? All right. All right, Mr. Moore, have a seat. We'll get you a paper notice. You're welcome.
Mr. Jenkins?
Mr. Jenkins? Jenkins?
Was it dismissal good?
It's a dismissal.
Okay, he's up there.
That's all right. You can send him on his way.
It just blew up from there, something that had never happened in 9 years. It's just crazy, crazy. I got to do all of a sudden, I lost a lot of weight and I really prioritizing that. I don't know. It's just like she just started eating it for 9 years. You know, I don't know. She also
Maybe
has a
she's lying.
boyfriend. She has a boyfriend in Mexico that can't come here. Her job is what keeps her from going there. So, that's all speculation. You know what I mean?
Morning.
All speculation. All right, guys, I can still go to work. See who's raising it.
What have you got?
She's Crystal, to make sure about the audition.
So I don't know if you, I'm hearing Malik McAllister. I had filed a motion to withdraw
Oh, yes, okay, yep, I remember.
So, yes, I would still like to do that. I would like to withdraw and,
Respect counsel.
yeah, and actually, I want to refer him to one of my associates.
That works.
So if we, so
Great counsel.
you know, having done appointed work for almost 40 years, people don't like appointed work.
Yeah.
So I'm gonna have him speak to one of my associates. If we could just adjourn the pretrial for a couple of weeks, and give him a chance to consult.
Is he
and-
here?
Yes.
Oh, good. Okay.
You want to adjourn everything today? Or you want to hold the motion?
I want to withdraw
Yeah.
and then just
Yeah.
get a new pretrial date. So
Come on up, Mr. McAllister.
however the court wishes to proceed.
All right. Counsel, go ahead and put your appearance on.
Thank you and good morning, Maria Manarino, P 39531, on behalf of Mr. Malik McAllister, who joins me and stands to my right. Mr. McAllister, go ahead and identify yourself.
Thank you. All right. Sir, counsel has asked to withdraw from your representation. Is that all right with you? Okay, I'll allow that. I can give you a court date, September 4 or September 18th, give you some time to hire another attorney. 18th? Still at 9?
Still at 9.
Okay,
18 in the morning.
yep, 9 a.m.
Thank you so
All
much.
right, okay. Mr. McAllister, we'll get you a notice for that court date, and you owe $200 on a registration plate violation. Are you in a position to set up some kind of payments on that one?
Yes.
Do that before you leave the building downstairs? Okay, all right, just have a seat, we'll get you notice.
That one, because something downstairs, that here it's so long. New courthouse, I haven't seen that courthouse yet.
When did we do that? The 18th or the 4th? 18th?
Yes. There you go. You want to wait here? Yeah.
What's going on? Yeah, so currently the way we had things set up was you, me, and Karen, any two of us could take their business. We had to have two signatures. So they'll allow just. Yeah. So I don't know if they'll allow two of you to go to the bank and set that up or all three of them. Because that's just the way it was originally, so, you know, if you were out of town, Jeremy could find me, and still take those. No, but I don't think they ever had to do anything other than deposits. But you know, if you showed up like checks, I always sign them. Come here. I'm pretty sure. No? Well, I don't know. I haven't even looked at the whole box of stuff. I haven't opened it. So. The way, yeah, what we were gonna do is I got a bad week and I'm leaving Thursday to take the meditation. Yeah, so Jeremy was gonna text me next week and we'd set something up. Cause I figured you were. Yeah, I figured you were probably more flexible than sure. Yeah, all right, so let's talk next week. All right, cool, thank you, bye. So I got an email.
Huh.
I just got an email. from Attorney Haddad's office saying they haven't made a big call. It's gonna be here at 10:05.
Because we don't have any,
It's 2 hours.
who the hell's even flying?
I don't know, but
Because we don't have anybody answering the phone.
Why?
Naomi's gone, Carol's gone.
Yeah, I know.
Nobody.
Yeah.
So, I mean, unless Mariah's in. Ferris got it.
would you see if there's a Mr. Haddad out there and let him know that we just got an email from his attorney's office saying that he'll be here about
You
10:05.
mean Zoo.
Rosu, right,
Yes.
Rosu.
Yeah, Rosu is here. He already checked in.
All right, so let him know Mr. Haddad's office said Mr. Haddad will be here at 10:05, which was 4 minutes ago.
The same thing here. Like to go back to the.
I hear, I got her.
Good morning, Your Honor. Good morning to your staff there. So that on behalf of Mr. Rosu, states, am I right? Day and time set for a show cause and a.
Thank you.
Judge, I was retained after this was set for show cause. My understanding from my client is he didn't show up for Zoom, but he did call right after. He's never used Zoom before and he had trouble figuring it out. He did contact the court right after and was set for in person there.
All right,
Happy to just stay in person, or if the court would like to go back to Zoom, obviously I'll show my use.
still at 9 o'clock on the 18th.
I'm wait, you already.
All right, counsel, would you waive formal reading?
We have formal ratings and stand mute, Your Honor.
All right, I'll enter not guilty plea. Pretrial date, September 18, live, 8:30 in the morning. You okay with a personal bond?
That'll be whatever.
All right, Mr. Rosu, am I saying that right, Rosu? I'm going to put you on a personal bond, 3 conditions. The first one's pretty obvious, stay out of trouble. The second one's pretty obvious, be here for court on September 18th. Third one, do not purchase, possess, or consume any mood altering substance unless you've got a doctor's prescription for the substance. You understand that? Can you live with those rules? Raise your right hand for me. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you mess up?
Yeah.
Any questions? You have a seat. We'll get you a notice in just a minute. Counsel, anything else?
No, sir.
Have a great day. You're welcome. Is it Mackins? Did I say that right? Come on up. Mr. Graziani, your appearance for Mackins.
Well, that's okay. John Graziani, bring on behalf of Patrick Mackins. Mr. Mackins, please step to the podium. Please identify yourself with Patrick Mackins. Simply asking for an adjournment, Judge.
September 18, 8:30? That work for you?
This savings is.
All right, you just have a seat. We'll get you a notice.
Being recorded, or is it going to you?
I'm sorry, what did you say?
Is it going to you?
Was he going to? He could go to Mr. College because he.
Okay, thank you.
state your name for the record? You may be seated. Case of the people of the state of Michigan versus Cody Jolly.
Andrew is appearing on behalf of the people.
Mr. Jolly, today, are you going to state your name for the record?
Yeah, Cody Lee Jolly.
All right, thank you. All right, Mr. Jolly, this is the date and time set for your preliminary examination, what we had set before. And since you're representing yourself at this preliminary examination, I'm going to once again apprise you that you are before the court on charges that allege that on or about August 10th of 2024 at the location of 2201 Hogback Road, Pittsfield Township, Washtenaw County, State of Michigan, that you did make an assault on a prison employee or employment or an employee of a place of confinement. You understand that charge, sir?
No, could you say more? Yeah, I understand, but I got the scope right here. I couldn't hear you there.
Okay. That is a felony punishable by up to 5 years incarceration, $2,500 fine plus court costs. You understand the maximum penalty, sir?
Yes, I do.
All right. And you're electing still to represent yourself?
Yes, I am.
All right. There's great peril in representing yourself. You need to be aware of that. The court won't treat you any better, won't treat you any worse by you representing yourself. I would further advise you that if at any point you wish to be represented by an attorney, then you should let the court know at that point. And I will do my best to arrange that you have an attorney to represent you. You understand that, sir?
I do understand.
Okay. All right. Are we ready to proceed?
Your Honor, the people are ready to proceed with their preliminary examination, and I did hear Mr. Jolly acknowledge on the record that he does have the police report now that was served, I believe, Thursday night or Friday by jail staff, and I provided the court with a copy of the proof of service. The people are ready to proceed. We intend on calling one witness when the court is ready.
All right, very good. And I do have the proof of service in the file. And you may proceed then, Mr. Tip.
Thank you. Your Honor, the people would call Officer John Apple to the stand.
Sir, please come forward to be sworn.
You solemnly swear or affirm the testimony you're about to give me the truth, the truth, and nothing but the truth, so help you God.
Yes, it is.
Have a seat, state and spell out your name.
Hello, I'm Officer John Apple, JOHN.
All right, you may inquire.
Thank you, Your Honor. Sir, how are you currently employed?
I work at the Washington County Sheriff's Office in the corrections division.
And how long have you worked in the corrections division of the Washtenaw County Sheriff's Office?
Approximately 18 months.
Okay. Were you working in that capacity of August of last year, 2024, specifically August 10th?
Yes, sir.
Okay. And you were working in the Washtenaw County Jail? Was your shift on that time, on that day?
I believe it was noon shift. It was 3 o'clock to 11.
3 p.m. to 11 p.m.? Okay. Directing your attention to around 5 o'clock in the afternoon or early evening on August the 10th, 2024, what were your job duties in the Washtenaw County Jail at that time? What were you doing?
I believe at that time we were doing our meal pass, make sure everyone gets dinner for the night. In the specific housing we were at, that was a door-to-door feeding unit, so you work with a incarcerated individual, worker, or trustee, go door-to-door do meal pass.
Okay, and what specific block or area of the jail were you working at that
I was
time?
working at A block, that also has our max housing unit and observation.
So it has max housing observation unit, and that is within the A block of the jail.
Correct.
Okay. And you said you were passing out dinner effectively?
Correct.
Okay. Are you familiar with an inmate by the name of Cody Jolly?
I am, sir.
Was that individual housed on that block at that time?
He was.
Okay. I don't know, Your Honor, is the screen that in front of Officer Apple the same screen that we're seeing, or is that screen black?
It should be this.
Okay.
Oh, no, he is, yes, he is seeing what we're, I guess, primarily that, the one that's moving.
Okay.
Is the one that he's seeing, right?
Officer Apple, can you identify anyone on this screen in front of you that you recognize from that date of August 10, 2024?
I can't, sir. I see our individual, Cody John.
Okay. And can you describe what they're wearing on the screen so we know who you're talking about?
Orange pants and a white long sleeve t-shirt.
Thank you. Your Honor, may the record reflect identification of defendant Cody Jolly.
Record shall so reflect without objection.
So Mr. Jolly was housed on A block and that's where you were passing out meals on August the 10th of 2024?
Yes, sir.
Okay. What, if anything, occurred when you had an interaction with Mr. Jolly on that date and time?
When I approached his door and breached his door to pass him his dinner for the night, he asked me if he could have another tray. He was sitting on his bed in the unit at the time. I told him that, you know, if I have any extras, I'll circle back to him. And when I turned to collect the beverage for him, he began to stand up, and I believed that he was coming to approach me to grab his drink. But at that point in time, he began to strike me in my head and face area. We got a bit of a scuffle. I tried to gain control of Mr. Jolly. He kept delivering strikes to me. So I delivered strikes back in self-defense. Was able to gain control of Mr. Jolly to the point where I could get back to my radio and essentially call for backup. And the jail called an available officer call.
Okay. And I'm going to just unpack that a little bit, Officer Apple. So you passed Mr. Jolly his tray of food,
Right.
and then you had turned to retrieve the beverage from the cart.
Right.
And where was that cart located?
It was just off to my right, so it was almost right in front of the store. I had an inmate worker helping me pass trays at the time, so I turned to him to get the cut. As I faced Mr. Jolly, he began to stand up. Like I said, I believe he was coming to meet me halfway for the beverage, and he began to strike.
Okay. Other than yourself and the inmate who was assisting you, were there any other corrections officers in that area at that time?
No, sir.
Okay. Did Mr. Jolly say anything to you as he stood up and began, I guess, to kind of advance towards you?
No, sir.
Okay. You said he struck you in your face.
Right.
Do you have any idea approximately how many times?
3 to 4 times.
Okay. Do you recall, was that closed fist, open fist, slap? Can you give us any detail?
Close fit. So it was kind of towards the top left side of my head and my face.
And
Took my glasses off.
Okay, so kind of, you said left side of your head, above your eye. Is that a yes?
Yes, sir.
Thank you. After he struck you a few times, you were able to basically strike him back in self-defense and eventually get control over Mr. Jolly. Is that fair to say?
Yes, sir.
Okay. Did other jail staff respond to assist?
Once I got control of Mr. Jolly and was able to get back to my radio, during the scuffle, I got knocked off as well as my glasses. So I was on top of Mr. Jolly at the time, was able to recover my radio and get that call out, and then other officers did respond.
Okay. Did you suffer any sort of injuries from this?
Superficial injuries, bruising, soreness, no long-term surgical. And I did get sent out to St. Joe's at the time, or the Trinity Health emergency room, and then I had to do a follow-up, make sure I didn't have a concussion or anything before I could return.
Okay. And just so we're clear, the Washtenaw County Jail, is that located? I can never get this right. Is that technically in the city of Ann Arbor? No, Pittsfield Township. Okay. In Washtenaw County. Thank you. I have no further questions. All right.
Okay, Mr. Jolly, do you have any questions for Officer Apple?
No, I do not, not this time.
You have no questions?
Not at this time, it's pre-trial right now at this time.
All right.
Your Honor, I have no redirect. I have no further witnesses and the people would rest.
All right, you may step down, sir. All right. Mr. Jolly, do you have any witnesses that you'd like to call?
I do not, just to remember, this is pre-trial, correct?
Well, it's a preliminary examination, Mr. Jolly.
Okay, all right, I was told it was pre-trial, that was the last court date, and then you told me you were rescheduling it for pre-trial, and so I don't know where we're at in the process. It was my understanding these last two have been pre-trial.
No, they were PCC and then your preliminary examination, sir. And today is your preliminary examination.
Okay, so okay, so what is my next one then?
Well, I don't know yet. Do you have any witnesses that you want to call today?
No, I do not. I just,
Okay. Do I have a motion?
So, Your Honor, my question was that it's been over a year and I'm just trying to get to pretrial. And my understanding was these last two cases were both pretrial. It's been over a year. And for some reason, we still haven't got pretrial yet. Can I ask you why?
Well, I can tell you that you had a competency evaluation that there was an issue with you participating in. And then there was always the issue of your participating in all of the proceedings as they were set. So the matter could not move until there was a motion that was filed by the people, given your reluctance to participate.
Okay, well, that motion was.
So Mr. Jolly, I'm not going to sit there and argue with you. I'm here now with your preliminary examination. You don't have any witnesses. Do I have a motion from the people?
Yes, Your Honor. At this time, people would move to bind the defendant over as charged on the one count before the court.
Mr. Jolly, do you have a response to that?
I didn't hear. Can you say that one more time?
Pardon?
I didn't hear what he had said.
Your Honor, the people would move to bind the defendant over on the one count before the court and ask this matter proceed to circuit court for further proceedings.
Do you have a response, Mr. Jolly?
So, okay, my response is to move it to circuit court. We're talking about conference then. Is that correct?
Pardon?
Or if we move it over to circuit court, then we're on to conference. Is that correct?
On to conference?
Is that, yeah, he just said move it to circuit. Does that mean we're on to conference? That was my understanding, is that we're moving to conference. That would also be my request too.
Well, I don't know what you're trying to say. All I know is that what the people have asked is that the matter be bound over to circuit court for you to stand trial there.
Right, which would be moving from here to conference, which is right before trial, correct?
You would have different proceedings before Judge Slay, yes.
Which would probably be conference, am I correct?
Sir, you will have different proceedings before Judge Slay.
Okay.
Do you have anything in response to the people's motion to bind over?
You know, I would prefer, my response is to prefer to move on to conference. That would be my response to that. And then I also have my own, I would like to request again. I put in the motions for jury trial, a 12-person jury trial. And I also put in my motion for 45-day speedy trial. I am also requesting those as well again here today. Motions were.
The court has heard the testimony in this case from Officer Apple. The court does believe that the people have indeed sustained their burden of showing that the defendant was in a place of confinement, that he also then assaulted an employee of that place of confinement, And so for those reasons, the court would bind the defendant or find that people have established probable cause that this offense was committed and that the defendant committed it. And the defendant would be bound over to circuit court to stand trial. Jolly, you're now proceeding into what will be your circuit court arraignment.
Right.
I bound you over to stand trial. I'm now going to conduct your arraignment regarding those proceedings. So I would advise you are before the court on a complaint that alleges that August 10th, 2024, at the location of 2201 Hogback Road, Pittsfield Township, Washtenaw County, State of Michigan, that being the Washtenaw County Jail, that you did, being a person lawfully imprisoned in the jail, did assault a John Apple, who was an employee of a place of confinement or other custodian, knowing the person to be an employee or custodian, through either the use of violence, threats, violence, or dangerous weapons while you were awaiting trial, contrary to Michigan statutes. Do you understand what you are charged with, Mr. Jolly?
I understand what I was charged with this to do.
Okay, that is a felony. It is punishable by up to 5 years incarceration and a $250 or $2,500 fine plus court costs. You understand that, sir?
I understand that.
All right. I do also have to advise you that if you are convicted, law enforcement is to collect a DNA identification profile sample before sentencing or disposition if it was not taken at the time of arrest. You understand that, sir?
Yes, I do.
All right. How do you wish to plead to that charge, sir?
No, not guilty. I also.
All right. The defendant, having heard reading of the information, pleading not guilty, court will enter that plea. A pretrial in this matter will be set for
September 25th at 1:30 for Judge Fleischer.
September
25th.
25th, 2025, 1:30 before Judge Slay.
Okay, my request for jury trial and speed, I requested a speedy trial already, and I did file these motions. Now, can you, is this where I bring this up again? A speedy trial.
You can bring those up before Judge Slay.
I've already requested it before you, though.
I know. So what I'm indicating is that I am not making a ruling on those because I don't have to. First of all, in regard to any delay in these proceedings, Mr. Jolly, you were the cause of the delay. So I think that any reference you're having towards speedy trial,
There's a right to speedy trial.
it's really your issue. Your issue to a trial by jury is intact. You will have your trial by jury if that's what you wish. Again, you may raise all of these issues before Judge Slay.
I did request a 12-person jury also.
In circuit court, that's the way it rolls.
And so that's the way it goes to the speedy trial. I don't have what you're saying. I don't have a right.
You can raise that if you think that you have been denied that. My ruling is that there has been no violation of any right you have to a speedy trial, because any delay that has occurred in these proceedings is either an acceptable delay in terms of the competency, but also any other delay was a result of your conduct.
It was 30 days
that delayed these proceedings. Mr. Jolly, I'm not going to sit here and argue with you. I'm telling you what my ruling is. You may raise that issue again if you like before Judge Slay. You will get your jury trial. That will all be set before Judge Slay, and you'll be able to proceed there. At this time, these matters having concluded, your bond is continued. Thank you.
Right. Either way, yeah. Good morning. Are you as scared as you look? Calm down. You're not going to jail today. All right. Your name is Blankenship? All right, and you're going forward today without a court-appointed attorney, correct? Oh, Miss Medina? Did you talk to Miss Medina? Oh, all right, you spoke to the prosecutor. Yeah, all right. That lady doesn't work for you. She's very nice and she wouldn't take advantage of you, but she works for the city of Romulus. Okay? Do you want to talk to an attorney that represents you, or you're okay with this deal? You want to talk to an attorney about your options? Okay. Have MIDC talk to Ms. Blankenship. Take the file so they can see what she's got.
Peter, I mean, that's what Peter, my computer was. I don't know. Right, because she shouldn't need to speak to her. Okay, I'll tell Joe just to bring her in the courtroom. All right, bye. Mona Avery show causes, it's been here since 8:30 and she's getting bounced around. What did Miss Blankenship just do?
Decided to talk to an attorney. So, you understand those rights and the
Ms. Gray is currently on probation. To a disorderly person, my understanding that that plea is to be taken, or the recommendation is for it to be taken 771.1 for a period of 6 months, Your Honor. Ms. Gray is currently on probation. Her probation officer is here and her probation officer is aware of this incident, Your Honor.
Thank you. How long have you been on probation?
It just started.
So you were on probation, or this happened before you were on probation?
Yeah.
Right, all right. So have you discussed your rights and options with counsel?
Yes.
You understand those rights and the options they give you? You understand the possible penalty for the charge of disorderly person? Understanding all of this, are you pleading guilty to the charge freely and voluntarily? On October 24, tell me what happened that makes you think you're guilty.
I think it was October 23rd, Your Honor, I believe. No, 24th.
Offense date and file says 24. Could be a typo. Let's see what the appearance ticket says.
October 23rd, 2024, member of the city of Romulus on that date?
Yeah.
And ma'am, were you part of a disturbance at the McDonald's on or around 9777 South Wayne Road?
Yeah.
And were did your actions that day cause the peace and quiet to be disturbed of the people that were at that McDonald's?
Yeah.
You satisfied, counsel?
Satisfied, Your Honor.
So am I. What should I know about Miss Gray before I sentence?
Your Honor, Ms. Gray currently lives with a friend in Farmington. As indicated, she is currently on probation. She did just go down to speak with court employees regarding her outstanding balances, Your Honor. So
Good.
she's expected to be on top of that.
Good.
She's currently a contingent employee of a medical team. And I would ask that the court consider the fact that she's here accepting responsibility. Previously, she had been before, Your Honor, and she indicates that she was a little confused by the questioning today. We were better prepared for that, Your Honor. Thank you.
So our address for you in the file is Annapolis in Inkster. That's not a good mailing? All right, you want us to use that Farmington address?
It's a PO box, I think.
I've got 29. What do you got in the computer? You got Annapolis?
Downstairs.
No, but it should be like a forwarding PO box.
Oh, P O Box 3511 in Farmington?
Yeah.
Okay,
Okay.
I'll change it to this file.
All right. All right, are you working now?
She's a contingent employee at.
Yeah. Yeah. What's that look like? I mean, how many hours a week do you average?
It's probably day 16. This week I worked 3 or 4 doubles and 2 extra days just so I can try to get.
Right. So you can pick up extra when you need it.
Get when it happens.
Yeah. Yeah.
In between, buildings, because the building, in Westland, I was supposed to transfer out, but the other buildings don't have an open availability for me, so I just have to.
Right.
So it's been a struggle, but they want to work on it.
You get good transportation? You're legal to drive, all that stuff?
Yeah, my license is good.
Yeah.
It was a restriction, but the restriction. Yeah, that's what I'm hearing.
Yeah. So here's what I'm going to do. And I understand you're living in Farmington, so I'm just going to give you the choice. It's $400 or 4 days on the court work program. So if you can, the days you pick them, you schedule the days. But when you walk out of here, you'll have a schedule. Each one of those days, you have to be back here that day between 8 and 8:30. Right? If you do that, then I won't charge any more money because you're already $2,300 in the hole with us. All right?
So would you prefer to pay the 400 additional that you're already owed, if you said 2,000, or are you gonna sign up today for 4 days on the work program that are pre-scheduled?
And that's here, the previous.
You'll have to be here. Right. Right. Right.
But then I can just not work the day shifts and, not pick up the day shifts and just come here.
You schedule, for example, you'll walk out of here today with 4 days on a schedule, and then you can work your real job around those. All right. And that might be, I don't know if they're talking to you about that downstairs, but we might be able to take care of some of that $2,000 the same way. All right. You're welcome.
Maybe there's an additional money
Right.
that could be waived based on that work.
Yeah.
Yeah. Work and no additional fees.
Right.
Thank you
Right.
so much,
And
Sharon.
remember that when you're talking to those people down there, they all work for me. So you tell them that Judge said I might be able to work off some of my money on that $2,300. And if we have to, we'll have another conversation.
Thank you very much, Sharon.
Welcome.
Have a great day. Yes,
Bye, nice to see you tomorrow.
Oh, yes, tomorrow.
What's the name, Joe?
Yeah.
Only one of them. Come on up on Allen.
Judge. Good morning again, Judge and staff, John Johnson, and me at the Robert Allen. We received a reduction in operator's license.
Yep. All right. Good morning, Mr. Allen. Did you discuss your rights and options with counsel? You understood all those? And you understand the possible penalty for the added charge? Understanding all of this, are you pleading guilty freely and voluntarily today?
Yes.
Did you drive a vehicle in Romulus on July 16, 2025? Was your license suspended, revoked, or denied? I'll accept your plea to the added charge, dismiss the original charge. What's the status of your license now? Still suspended? You know what you have to do to get it straight?
He's tried several times, Judge. This happened from an unfortunate incident when he was about 18. He was very young, obviously. I'm simply asking for mercy at this time. Seems like everyone's got a story that makes the profession interesting. He was working at John's on the Lake. In fact, he was a chef over there in Belleville. And he's currently on a workers' comp case. And I usually think on a workers' comp case, you can get payments. Normally he gets the payments. He has not received payments. We have hired an attorney, correct, sir? And
How long since you worked? Excuse me, counsel. All right. Last year? So over a year now. Whew.
family,
Right.
the park bench.
Right.
And also on that.
Okay. Okay. All right. Are you physically, you're able to work? All right.
What's the?
Say again?
What's the?
Okay. Okay. Hot oil. Ooh, ooh. What are they telling you? All right. So you're hopeful? You think, do you feel like you're ready to go back? Yeah. So you're not there yet. Okay. All right. All right. I'll tell you what I'll do. I'm not going to do any fines or costs. I'm just going to do 30 hours community service, which means charity work. So find some charity you can do sitting down. Just hook up with some nonprofit, volunteer with them for 30 hours, document those hours to the court, and it'll close this file out. All right. So somewhere you can answer phones for them, do some paperwork for them, whatever you can find. I'm going to give you till October 1. All right. If you're getting it done and you need a little bit more time, I'll work with you there. Yeah. Good luck with the foot. Maurice Booker. Morning, counsel.
Good morning.
Your parents.
Alex Green, the fourth P 8657. My name is the attorney appearing with Mr. Maurice Booker to my left. Would you please state your name for the record? Maurice Booker.
Good morning, gentlemen. All right, counsel, no objection to a dismissal?
Got it.
All right, I will dismiss the assault and battery charge from October 28, 2017. Mr. Booker, looks like you're waiting for a hearing date on some Romulus traffic matters. And looks like you owe us money on, those same ones. All right, so there's your hearing dates pending. And then I've got a 2018, all it says is non-public that he owes $770 on. Can you tell me what that is? What case number?
1625.
Yeah.
No,
Oh, all right. So we've got from 2016, we've got a no valid operator license on person charge. Shows a balance of 770. No, that's not right. It was 774.
it was 774. Because of all the late fees, it was up to 1100.
They just didn't add it up.
Oh,
Yeah. All right. So are you in a position to set up some payments on that one? What I just told you, a no valid operator's license.
See, I just got my license back, so he wasn't on it.
Okay. The fact that you owe us money wouldn't stop you from getting your license. Okay. There's no suspension. There's no suspension. I don't know. What does that mean?
Pandemic, right? So we couldn't go to court, right? So I had to-
If this was 2016, the pandemic was 19 and 20. Okay. All right. So my question is, are you in a position to set up some payments on that 700? All right. What do you want to do? How much? How often?
I can pay fee
When can you start?
next month.
September or, today's August 4. So can you do anything this month or not? What day?
Probably next 2 weeks, I can pay fee.
I'm just looking for it.
So you want to do 50 a month and start like the 15th of this month? Okay, go downstairs and they'll give you a paper payment plan to walk out of here with. All right, good luck. This is the one I just dismissed. Then I don't know what that means. I'm hold waiting for hearings. Kylene Myers. Is that yours?
Yeah.
Go ahead.
Good morning again, Your Honor. Alex from the fourth P 8657. I'm appearing on behalf of Highland Myers. To my left, would you please state your name for the record? Highland Myers.
Were you at 8:30 on the 19th or 18th?
8:30.
All right, how about September 18, 8:30 in the morning, gentlemen?
Yeah, that's not bad.
That's fine, Your Honor.
All right. And Mr. Myers, looks like you owe us a lot of money on some other stuff. You know about that? Are you in a position to do something about that? We send you downstairs to talk about your options?
Yeah.
What do you say?
Yes, he said he was.
All right, I'm gonna send you downstairs, talk about options down there. And Mr. Myers, have a seat. We're gonna get you a paper notice for this September 18th date.
Mr. Green, I think I must have voted on that, or do you?
No, I'm just for today, I'm covering, so I probably, yeah, I'm not returned. Yes. Just want to make sure it says to adjourn, it's covered as well.
I just adjourned it.
Oh.
Yeah.
The other two, I have adjournments now, put them on that same day.
Okay,
Okay, so just keep it as a MIDC, don't assign you.
no,
Okay, I'll just do MIDC, so whoever's helping that day.
got it, yeah,
So I'll, they'll get adjournments for September 18th as well.
yes.
All right, you're all set?
Oh, I wasn't-
Yep, just have them wait and I'll give them notice.
Oh,
For,
okay, great,
more Ruzi and Hugo Glacius.
yeah, yeah,
Yep, I'll get them adjournment dates.
okay, great.
Talk to her, she didn't go forward without counsel.
Ms. Blankenship. Who's the lady sitting? All right. Are you ready to go forward with that deal? Yep, without an attorney? Yes? Okay, I'm not sure how far we got before, so we're just gonna start over. You read your rights, you understand those, right? And you understand the options those rights give you, correct? You understand the possible penalty for no valid operator's license on person? Understanding all of that, are you going to plead guilty today? Are you pleading guilty to the no valid operators? All right, and are you doing so freely and voluntarily? All right, did you drive a vehicle on October 20, 2024 in Romulus? At that time, was your license suspended, revoked, or denied? One of those things? Yes? All right, I will accept your plea to the added charge, dismiss the original charge. What's the status of your license now? You're valid. Great. Are you working? Where at? Where at? Okay. All right. Not too bad. All right. Full time? Good. How long you been there? Okay. All right. Looks like you've got another court date coming up. Oh, no, that was last week. What happened on your felony charge? Did it get adjourned?
Yeah.
Okay. All right. And it looks like you currently owe us $336 on an impeding traffic ticket. Probably you got the same day you got this misdemeanor charge, right? Yeah. Are you on a payment plan on that one?
Yes.
Okay. You're current? You're on track? All right. Anything else you want me to know before I sentence you? Why were you suspended? On October 20th, your license was suspended, right?
I think.
Okay. Okay. You got all that taken care of though, because your license is back. Okay.
Me and I was driving, they see one in the car, and they had their battle.
Yeah. Yeah. Right. Okay. Okay. All right. What's your current payment plan with us? How much are you paying? How often? Okay. All right. How many hours a week do you work at the job? Good. Great. What do they pay? give Mr. Taylor a call and see if he keeps track of jobs that are available in our area. Give him a call and see what he's got that might be a better fit for you closer to home. You can do that? What am I doing with this?
That's for Wednesday.
Oh, thank you.
Hey, can Mariah or Vanessa or anybody downstairs call me, please, at 225?
I'm going to do money or I'm going to do community service hours, charity work. What do you want to do? You want to find time for some charity or you want to have time to pay on money? Good answer. 40 hours community service by October 1. If you need more time, don't come to see me and say, I haven't done any hours, I need more time. If you come see me and say, I've got them almost done and I need more time, the answer will be yes. Understood? So you can, if you go downstairs to the probation counter, which is basically that end of the counter, ask them for our list of pre-approved community service. You can go anywhere that's a charity, right? Any nonprofit, church, soup kitchen, Salvation Army, but we've got some that are already approved if you want to start there. You got it? Questions? Have a nice day. What's this lady? What's the part here?
I don't know her name, so I don't know if she's waiting for an adjournment. I don't know.
Okay.
Because, well, then she's not being part of it. She's kind of waiting for.
And what's your name? In the back?
Kennedy.
Kennedy, yeah.
I'm ready to go back and figure out.
Okay, so
I don't know what she owes. I don't know what she owes in hours or money. This show cause notice doesn't tell me anything. Do you know what you owe?
Which I was making payments on a regular basis to Mr. Taylor. And I thought it was all caught up. And then I got this thing in the mail saying that I had to come before you. And
Right.
I went and I got the plates and insurance on my vehicle, which is what I was ticketed for.
Right. Have you changed your phone number or anything? Because he says he's been trying to call you and can't get hold of you.
But I lost my job, so my phone got
Shut off. Right.
So he may have tried while my phone
Right.
was off, but
Just feels
I'm
one.
Shows 120? Okay.
I've been making payments on a regular basis.
Are you still not working or are you back to work?
Oh, I don't have this.
Okay. All right.
I don't work anymore.
and then Your Honor, if I may.
Not yet. Go ahead, counsel.
Oh, it's just that, and this was probably furthermore a little bit confusing, to Ms. Kennedy, because she had some similar charges this year, and so those were resolved. So these are a couple years old.
Mhm.
I did look, to see cheaper insurance.
Right. Okay. So you don't have to do the community service. That was a way to close out the money.
Right.
So we're perfectly okay just doing payments if you want to do it that way.
I was off on them.
Right,
Like he was saying, he could understand the confusion. I didn't know I still followed.
right.
Got this to say, come see you.
You're here. Yeah,
Sure.
okay. All right. Did we charge your appeal cost for today? Is that part of the 120? And is it a monthly payment?
Yeah, I was making a monthly payment.
What did you make your last one?
No, he did not charge us.
$50, but I think it was the last one I paid.
Yeah, when?
Pardon me?
When was your last one?
I don't remember.
Has it been a while?
It's been well, this year, but it's been.
Okay, all right. So can you do monthly payments?
Social Security,
Okay,
and I not even able to pay my rent with that.
okay. So what can you do?
How much do I owe?
120 right now.
I do like $25 a month, $50 a month.
I usually don't do less than 40, but if the most you can do is 25, we'll do 25. When do you want to make your first one?
I don't get my next tip for September. And if I can, I'll pay a little more.
So you usually get your check like the 3rd-ish, right?
You're right.
So September 5th, too tight?
That's fine.
You sure?
That's fine. Yeah.
All right, once again, the problem was he couldn't talk to you. So that's why we sent you the mail. All right. Yeah, and then your phone got shut off. Yep, I get it. All right, so go downstairs and set up that payment plan. All right, you're all set. Oh, that was all together. That's all her stuff.
Thank you.
It's $25 a month, Judge.
Yeah. I don't know. Certified mail, and then they have no email and we've not received it yet. So that means they emailed the party, I'm assuming.
I don't know how it is, John, there.
A clarification, this 1 o'clock, it says emailing, we've not received it yet. So you've emailed asking for proof? Oh, we haven't received that yet. So at this point, it sounds like everybody's served. Right, right. Okay. Yep, thanks. Smith. Sorry, Ms. Graziani, I didn't see the paperwork come in.
Working very hard. For the record.
Good morning.
Cortez Smith, please state your name, sir. Cortez Smith, and we're prepared to accept this very generous offer.
Yeah, and you know I'm gonna get it down to one file.
Yeah.
Instead of the two. All right. Mr. Smith, the prosecutor sent it in so that we'll process two files. I like to save Heather the work, so I'm just gonna have her process one file and dismiss the civil infraction outright. I'm just gonna charge you a little extra money on the misdemeanor to get the prosecutor back where she wanted to be. Understood? Have you discussed your rights with Mr. Graziani? You understand those rights and the options they give you? You understand the possible penalty for the added charge today? Understanding all of that, are you pleading guilty freely and voluntarily? Did you drive a vehicle in Romulus?
Yes, sir.
And was that on July 1? Was your license suspended, revoked, or denied at the time? Mr. Graziani, satisfied with the plea? So am I. I'll dismiss both the original tickets. What's the status of your license now, sir?
I have an appointment with an attorney to, start the process.
Go to the appeal? Good. Good luck.
Thank you.
Are you working, sir?
Yes, sir.
Where do you work? Yep. How long you been with GM?
Over 3 years.
Good. What kind of shift you working? Okay,
These are the fiance that takes it.
good. Okay. Anything you want me to know before I sentence you, sir?
I made a bad decision on that day to leave out on lunch break. And that's what got me taken. I never left out, so since
Right.
that issue, I corrected the problem by cooking home dinners or.
Good. 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 Yeah, yes.
Okay.
Yeah, but just to be clear, I looked at the appearance ticket. It wasn't your hunger pangs that got you in trouble. It was your speeding 65 and a 35.
Yeah, trying to get back to work, yeah. But if I didn't leave out for lunch.
Can't argue that. Can't argue that. All right. All right, so normally on these cases, I would order 4 days work program in lieu of jail. Our work program, you got to be here. You schedule the days, but the days you're scheduled, you got to be here before 8:30 in the morning. You're usually back 2:30, but how's that going to work with work? Are you working 6 days a week now? What are you working?
Yeah, it kind of on the 6-day work.
You got any layoffs and shutdowns come out? If you know of. All right. All right. Yeah. All right. So what I'm going to do is instead of the jail, instead of the work program, I'm going to let you do community service, which is charity hours, and those are flexible. I mean, you can find some place on a Sunday morning to do that.
Okay.
All right. All right. So what I'm going to order is fines and costs of $500 and 36 hours charity work, community service. And I'm going to give you until October 1 to do that. So what I tell people all the time is don't wait to the last minute, come and say, I haven't started yet. I need more time. Cause I'm going to tell you no. If you come in and say, I've got 30 hours done, I just need a couple extra weeks to get it done, I'm going to say yes. All right. And you need payment options on the 500.
Yes.
Go downstairs and they'll give you all those options.
Thank you so much.
You're welcome.
Here you go. Let's have a good day.
You as well. There you go. Ryan Woodruff. Counsel, I think we set a couple more for you 8:30 that morning on the 18th.
Okay,
We'll just do this one at the same time.
that's fine.
All right. Adjourn. Mr. Woodruff. Oh, I'm sorry. Counsel, your appearance.
In your honor, Alex, report 82657, appearing here with Ryan Allen Woodrow. State your name for the record, please. Ryan Woodrow.
All right, Mr. Woodruff, that worked for you, September 18th for your next court date, 8:30 in the morning?
Fine.
We'll get you a paper notice in just a minute.
All right, thank you, sir.
You're welcome.
Is it Corny or Ryan that we're doing?
Ryan Allen Woodruff. I didn't see that took a long time. Yeah, haven't seen that one in forever. Okay.
Counsel, what's your client's last name?
James.
Yeah, Daryl.
It sounds like that.
She is doing something. Judge Payne's from the essentials, but they meant for she.
Yeah, I got it. I got it.
Scratch.
Counsel, they tell me the prosecutor's tied up in the other courtroom right now, so as soon as she's available, we'll get you up here. Lady behind counsel. She's with them.
I'm just looking for the date. Both the officer and the complaining witness were notified of today's hearing and they needed to be present in person. I have not received communication from either of them, indicating that they were not available to attend today. It looks like the officer was subpoenaed. A letter was made from, like a little over 2.5 weeks ago. Witness, the officer was notified, by email, Sergeant Nippes, on July 20th today, and neither of them have appeared.
Case dismissed without prejudice.
Thank you.
You're welcome. Hey, Joe, make sure James knows he's got a probation violation scheduled for August 12th. I missed that.
And identify yourself, Mr. Naylor.
I'm gonna shift jewelry.
Thank you.
Judge, we accepted the offer over here, but this is an unusual settlement. He obviously been given address. He is currently homeless. He lost his job because of this incident, but he.
Where were you working, sir? Go ahead.
And his sister threw him out for whatever reason. So he doesn't. Her.
All right. So you're living in your car, you surfing from couch to couch. What are you doing? Okay. All right. So, how did you get here? What route did you take?
94.
Okay. All right. So you know where you pulled in the driveway. When you leave, instead of going out and turning right to go back to 94, turn left, go around this building and you'll see a sign. It's the old courthouse and the sign says Wayne Metropolitan, whatever it says. All right. Wayne Metro. Go there and they've got lots of resources. They have special programs for homeless folks. Sometimes they have housing ideas, you know, okay. So go, when you're done with us, go see them and see if they can help you out at all. You got that? So don't turn right to 94, turn left, and it's the very first driveway. Turn in there and park, and you're going to go in the building. It's on the side of the building. All right? Okay. All right. So on this file, did you talk to counsel today? Do you understand your rights? You understand the options those rights give you?
Yes.
Yes. You understand the possible penalty for the no valid operator's license on person charge. Understanding all of this, are you pleading guilty to that charge today? Yes.
Yes.
Are you doing so freely and voluntarily? Nobody's making you do this, correct? Okay. Did you drive a vehicle on July 15, 2025 in Romulus? Yes.
Yes.
At that time, was your license suspended, revoked, or denied? All right, I'll accept your plea. All right, you're currently on a payment plan? All right. What's your payment plan? What's it require you to pay? Are you paying monthly, weekly? How much?
35.
All right. Are you coming up with that? Can you do that? Okay. You got a car, you're driving, you got a license, all that stuff? I can do, here, you owe us $855 currently, plus today's file. I'll give you a number of work days. If you show up every day you're scheduled, you show up here, you'll go out and work that day, you come back. I'm thinking, how many days? I'll do 8 days and that'll close everything. That'll be today's file and the $855. Can you do that? You want to do that to be done with it? All right. So you go downstairs and you schedule those days. You can do 8 days they have. The first 8 days they have, you can spread them out. I don't care, however you want to do it, but that'll close us out. They'll probably be able to use you tomorrow. Okay. So that way it'll save you $35 a month and just be done with it. All right. I'm going to do 4 and 4. So 4 on today's file, 4 on the stuff that his payment plan's on. All right, questions? So get your schedule for the work days, then go over to Wayne Metropolitan and see if they can help you out. All right. Good. Yeah, definitely. Definitely. You're welcome, sir. Good luck to you.
Thank you.
But once again, just slow down. 90 and 70. Like the guy working at GM, 65 and a 35, when he knew he didn't have his license.
Well, and his first tickets, he had 26 and over, no proof of insurance registration plate because he was driving man-thing cars
Like,
and he's speeding. So he driving Mustang or whatever. Yep. And he's telling them he should be responsible for those because he's driving a company car.
That's probably why he lost his job, is because they looked at the ticket. So, kid working on fast food.
You have a picture of her early?
No, I didn't even ask her. She got it. So the 3 women took 9 kids. I think the oldest one was 7. But all on it, contributing out to Fairy Gold and to look for the very fairy treasure. So, well, they're from Danielle, go to dinner at Harlem. Well, Jessica had all the other kids. Her brother, at one point, Danielle looked at us and said, does he remember he's a dog and he can bite this? She said, my dog would have bit me 4 times by now. She said he was bucking like a horse. She said she's got a spot on her leg she didn't realize till yesterday that it's bruised. He kicked her, it's scratched, but he kicked her hard enough with a dog's paw that it bruised. But he said, she said, never tried to bite anybody.
He's the best dog.
Yeah, come on. She said there's between 20 and 30 wells, yanked it all out. They left 2 little pieces in that they couldn't get out. One was right at the pad of his nose. And so they just keep bathing him with hydrogen peroxide and hope it dissolves, because the bar, as the dog moves, that bar will just keep going. It only goes forward. It doesn't back out. It goes in. So, one of them might work its way up on the side of his lip. Yeah, but her buddy Kimberly's up there. Her husband's got 7 bear dogs. And she says, pull all these,
Hello.
pull all the ones you can, and they just keep.
How are you?
Did it ready. Hey, Judge. Terry, how are you? Good. How are you? Good. How's our buddy doing? Post-op.
He's in
Alaska.
He's on a cruise.
Yeah, I told him when he told me he was going to Alaska, I said, well, that's the best timing ever, because otherwise you'd be working when you're not supposed to.
And he's been working. And I told him, I said, dude, just what do you need? I can run out. Oh, no, I got it. I got to get out. I'm like, I don't know.
Well, it's so funny. We were texting back and forth. Well, it was like game 2, I think, after the state. And I said, so you're lucky. You got a wake up call. You get to make some lifestyle changes. Yeah, Terry already said I got to give up cigars. I'm like, I'm thinking to myself, you got to give up more than cigars. How about living off on the fast food stuff? But when I talked to him, when I actually talked to him, he says, I really don't eat that much fast food. He said, I
Okay.
State jail.
Leading to numerous.
Yes, sir.
Through 2 and
We need 2.
Yeah.
Yes. 24 CR 2340 is now called. The state of Texas versus Christopher John Smith. Is that you?
Yes.
Present with your attorney, Ms. Minaldi, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, sir, this indictment alleges that on or about October 11th, 2024, in Jefferson County, Texas, you committed the state jail felony of burglary of a building. Do you understand what you're charged with here, sir?
Chris, you have to interrupt.
Yeah, you have to speak out. Okay.
I can't think when
I'm sorry, what did you say? He's mumbling.
I'm trying to think when the date was.
Yeah, it was on or about October 11th, 2024. So what's that, 9 months ago? And it goes on to state, though, that you have some prior convictions. You were convicted of burglary, a state jail felony felony out of the 128th District Court of Orange County, Texas in March of 2007. And also you were convicted in the 128th District Court of Orange County, Texas on August 26th of 2016 of evading arrest or detention, a state jail felony. So what happens is if you found guilty of those two prior convictions and then this one, you are facing a state jail felony, though it is punished as a third-degree felony because of the enhancements that are included. Stand by, please. Some uniqueness on this, but so 1, 2, and 3 don't allege that they were.
They don't have to be sequenced. It just has to be 2 prior state jail convictions.
But 2 in sequence. It doesn't say they're in sequence.
They don't have to be in sequence. They just have to have 2 prior.
I understand, but in sequence, 2 in sequence bumps it up to a second-degree felony.
No, that's 2 regular felonies. 2 non-state jail felonies bumps it up to, if they're in sequence, bumps it up to 20.
That's correct. It has to be
Without
first, second.
sequence.
Yes.
The state jails, the 2 state jails don't have to be sequenced to make it a third degree, but to make it a second degree, the 2 non-state jails have to be in sequence.
And they have to be non-state jails.
Prior state jail felonies are a third-degree felony punishment. So you are looking, sir, at third-degree felony punishment, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty here, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for up to 10 years. And you would, among other conditions of probation, be ordered to pay restitution in the amount of $600 for, I guess, the damage done here. Is that your understanding of the plan?
Sure, yes, sir.
Yes, no? What do you say?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand, sir?
Yes, sir.
This pad's just not working.
The delay is.
It's more than a delay. It doesn't even show up, and then I have to work it twice, or I have to write 2 or 3 times for it. If I follow this agreement, you have no right of appeal, sir. How do you plead to this indictment, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraphs 2 and 3, which allege the burglary in 2007 and the evading arrest or detention in 2016, those 2 state jail felonies, are those true and correct as they are alleged? Yes or no?
Bars?
Yes, sir.
Yeah.
And are you pleading true and correct for those allegations voluntarily and because those allegations of those prior convictions are indeed true and correct?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document? Did you have to speak out, sir?
Yeah.
Did you understand it, discuss it with your attorney, or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence and without objection, it's admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. And paragraphs 2 and 3 are all true and correct, as you have stated, of those prior convictions. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. State's Exhibit 1 is made a part of the record for all purposes. Do you understand, sir?
You're having trouble
Is that good luck?
today. I don't know.
The ink runs out right in the middle of your writing your name. I think it's good luck in Haiti, but I don't think in the United States. It isn't.
Just a little bit.
$600 resolution.
What this means is we're doing a lot of writing. I'm going to find as follows. I made these findings already. Do you understand? I am following this agreement. You are mentally competent to make this plea. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from the State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I am now finding you guilty beyond a reasonable doubt of this state jail felony, though punished as a third-degree felony because of your prior convictions. And I am following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That is suspended, and you were placed on regular probation for 10 years. You're going to go over the conditions and terms of probation with the probation officer. You do well, it gets shortened to 1/3 of this time, and then you can move on with your life.
There's also restitution, $600.
Yeah, the restitution is in the amount of $600 to the complainant here, Tan Phung, Phung. And let me ask you, Mr. Smith, what are you going to do? You're going to get released here, as there's nothing else pending. You're going to get released here shortly. What are you going to do? You got some ideas?
There's something, there
Sir?
has a detainer.
In another jurisdiction?
No, this year didn't.
It's,
Does he have something else here in Jefferson County?
he was arrested for another issue, but it hasn't come up again in indictments, and it's not on, at least to my understanding, is not on the DA's office's radar.
Not yet. I'm keeping an eye on it. If something comes up, it would be I think it's a drug case, but
Yeah.
You've been in, how long have you been in custody? Since October?
Since the
Well, that was surfaced by now, huh?
you would think so, yes, but there was an arrest for it, but I don't show it's ever been presented to our office. But if I've got a note that we're going to keep an eye on it, and if it comes in, we're going to refuse it because it was less than a gram. So it's another state jail would just run concurrent with us.
Do you hear what he's saying? What the plan is?
We'll get rid of it. Yeah, we'll get rid of
Yeah,
it.
he says if it moves forward, they're going to refuse it. The DA, if it has to get up to the DA's office, which it has to do before it's indicted, then he said they're going to just refuse that. So you ought to be okay. So what are you going to do? Where's your family? You don't know? Are you gonna live here in the area or?
So,
Yes, sir. And do you have a skill or something, a trade that can,
I used to run casing and all that stuff in the oil
I'm
field.
sorry,
I used to run casing back in the oil field.
He ran casing in the oil field.
well, there's a lot of that around here. What were you making an hour?
Like 15 an hour.
Okay, well, that's about 40 grand in a year, just for that, you know? Okay, well, anyway, you've got a trade. Good luck to you. And see this lady. Thank you. Next is,
Do you want to take it for my next plea or do you want to?
yeah,
Okay, Kenneth Randall.
Anywhere else?
Kenneth Randolph, please. What are you going to do with Mr. Randolph?
Leading to the injury to an elderly person and dismissing the harassment charges in jail.
It's nothing small.
Bad.
Yeah.
I think small is afternoon. Randolph, we do it in all his cases, yes.
Trying to dismiss two of them and plead one, just leading to the injury, elderly.
Correct.
Mr. Randolph, that's you? Do you need to see Mr. Randolph?
Yeah.
Yes.
Right.
Right thumb, right here is the.
Right right in the box.
Yeah. Straight up and down. Okay, two more seconds, I'll go around with you. Every ink. Just every.
Okay, I've got 2050 here in the queue. Does this mean that 1531 and 1532 will be dismissed as part of this agreement?
That's correct.
Okay, that's your understanding? Kenneth?
Yes, sir.
You are Kenneth Randolph,
Yes, sir.
here with your attorney and the state's attorney. Ms. Manaldi, does the defendant waive a formal reading of this arraignment and this indictment? Can we proceed in summary fashion?
Yes, Judge.
In summary, cause number 24 CR 2050 alleges that on or about May 20th, 2024 in Jefferson County, Texas, you committed the third-degree felony of injury to a child or an elderly person. This is going to be an individual 65 years of age or older. Are we enhancing this
Yes, it is enhanced with second degree.
to, by what? This paragraph 2?
Yes,
And paragraph 2 goes on to allege that before the commission of that injury to an elderly person charge that occurred on or about May 20th, 2024, this state you were convicted of the third-degree felony of retaliation on August 29th, 2022 in this court in cause number 21-37356. So paragraphs 1 and 2 would constitute an enhanced third-degree felony, or in other words, second-degree felony punishment, which means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what you're facing here? An agreement has been reached where you would be placed on deferred or unadjudicated probation. This can be up to 10 years in length. If I sentence you to 10 years of deferred probation, you can be dismissed in 1/3 of that, or 3 1/3 years. Do you understand?
Yes, sir.
If you do well, you gotta do well, and I dismiss all the time. And it looks like these two other cases, 1531, 1532 will be dismissed as part of this agreement. Do you understand?
So,
If I follow this agreement, you have no right of appeal of your cases. Do you understand?
yes, sir.
How do you plead to this charge then? Guilty or not guilty?
Guilty.
this pad.
Yeah, mine's doing something.
Now it's showing widgets are unavailable. Do you even know what that means?
Yeah.
I don't even know how that showed up. What do I hit to get rid of that? See, now there's. It's marked up there. Yeah, it won't. See, it won't. Yeah.
For some reason, it's got real sensitive when you touch with your hands on the side.
Yeah, I've noticed that.
Six try. Okay, so if I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And in this prior conviction in 2022 of this retaliation, this third degree felony, as it is alleged in paragraph 2 of this indictment, is this true and correct?
Yes, sir.
And are you pleading true and correct to that voluntarily?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it?
Yes, sir.
Discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence without objection. Among other things, the state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, state. So help you God.
Yes.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is hereby waived.
Yes, Judge.
I'm going to follow this agreement and find that, sir, you were pleading guilty and true to paragraphs 1 and 2 respectively, which constitutes a third degree felony and enhanced to second degree felony punishment because of the prior conviction. You are mentally competent to plead guilty and true to those allegations. You understand and appreciate the consequences of pleading guilty.
Yes.
There's sufficient evidence from State's Exhibit 1 supporting your guilty plea to find you guilty beyond a reasonable doubt, but I'm not going to find you guilty so long as you follow the terms and conditions of probation here. The probation officer will go over these with you. Make sure you follow these. These are normal and customary, and actually most of these things or most of these requirements or conditions all of us have to follow. If you fail to do that properly, your probation could be revoked. You could then be found guilty and sentenced up to 20 years. So you don't want that. Anything else to add?
No.
Okay, here I'm tendering the probation papers. Do you understand what has happened today, sir? Okay, good luck to you and see the probation officer. Thank you. Thank you.
Here, I queued up our stuff on another tablet, Judge. That might be easier.
This has been a consistent.
I know. We're gonna switch you out.
So there should be some dismissals, huh?
Yeah.
On Mr. Randolph. 1531. That case is dismissed. And 1532 is dismissed. Great. Thank you. Next.
I don't have anybody else signed up, but if you want to start at the top of the docket, Judge, we can get some of those put it out. Yes, Don Dixon.
John Dixon, an announcement.
I don't think he needs to come out here unless you just want him to come out here, but him and I have discussed the offers. It has changed this morning from a offer of 15 years TDC to a cap of 10. So if I could just get 2 weeks to
You got
discuss
it.
what that looks like.
Yes, ma'am. That's Dixon and cause number 24 CR 2417. Reset 2 weeks at the request of parties. Go ahead. It's Colton Falk.
If I could hold it, Your Honor, I have paperwork I need to work here.
Great, thank you. Hendrick Franklin.
I am in conversation with Mr. Boyd about that one, if we could hold that one as well.
Okay, Clyde Freeman.
He's a sentencing judge.
We're ready.
Yes, Judge.
Clyde Freeman, please.
Last time we were here for his sentencing, it was reset due to him not being properly registered with the jail. My office has
Yeah, I remember.
has made efforts to contact the sheriff's department to get him registered. To my knowledge, he is properly registered currently, but I'm also not 100% sure on that because I haven't gotten any response in regards to that.
Are we 100% in this room? Are we 100% sure anything?
It's beyond a reasonable doubt that that is true, Your Honor.
Yeah, this is beyond all possible doubt. We talk about that. It takes less than that to convict somebody. That's good enough for government work, I believe, right? That's pretty certain. And again, sir, your name, sir, is
Clyde Freeman.
Mr. Freeman. Yes. Well, there you go. And we now call 25 CR 403. And Clyde Eugene Freeman is here with his attorney, Ms. Minaldi, and the state's attorney. Earlier, sir, it looks like you pleaded guilty to this indictment, charging you with the third-degree felony of failing to comply with sex offender registration requirements and a pre-sentence report has been prepared. Have the parties had an opportunity to review it? And are there any corrections or changes to it? State.
No, Your Honor.
None from us, Your Honor.
It's made a part of the record for all purposes. And the agreement here is that the defendant is looking at a 5 years imprisonment cap. So if convicted, he is looking at no less than 2 nor more than 5 years confinement in prison. He could be placed on deferred or unadjudicated probation and regular probation.
Sure, Judge.
He could be sentenced to no less than 2 nor more than 5 years confinement in prison. That could be suspended and he could be placed on regular probation for up to 10 years. And am I right in all the options?
Yes, Your Honor.
All right. And everybody has reviewed this and no objections, state as well.
No objection, Your Honor.
It's made a part of the record as well from the defense.
Yes, Your Honor.
It's made a part of the record for all purposes. Go ahead, Mr. Freeman. What would you like to say, if anything?
I'd like to apologize for not handling my responsibility for one thing. And I also want to let you know that I got some supporters out there that are willing to give me a job if I'm
What would you be doing?
construction work.
Yeah.
Yes, ma'am.
I believe it's with a submit, he does that does local construction.
Perfect. Mike. Perfect.
I'll be on this. Just get out of the meeting.
You did complete your high school education? Did you?
I got a GED.
Yeah. You've done cement work in the past.
Yes, sir.
You got certificates in welding and material handling. What's material handling?
Material handling as well. Like, shipping in, receiving in, shipping out.
All right. Okay, the pre-sentence report is reviewed and made a part of the record for all purposes. Go ahead. What is the state asking for?
Your Honor, the state is asking for 5-year TDC. Again, the sex offender registration requirements are there to protect the community. We know how serious these offenses are, and I believe the defendant's been given a break by being given the cap here, and so we believe the 5 years is fair.
Okay. What's the defense say?
Well, Judge, I clearly disagree with the position of 5 years TDC. We are here asking you for probation today. He is very aware of the mistakes that he made that led him to the position that he is in now. He has accepted responsibility for those active decisions to evade his responsibilities. He knows that those are responsibilities that he will have to ensure are taken care of if he is put on probation. And he is positive about his ability to be successful in doing that. He has support on the outside. His family is from this area. He will have a decent paying job to help him work through probation and to ensure that he is successful at these things on the outside. So we are asking for probation from him, for Your Honor. Do you have anything else that you want to say?
All right. If nothing further, I'm going to find as follows then that Mr. Freeman, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty to this third-degree felony of failing to comply with sex offender registration. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt here. The battery died. I mean, there's nothing else that can happen to that machine. I'd be shocked. There's everything that could happen has happened on that machine. And so there is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of failing to comply with sex offender registration. I am following this agreement. You hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years confinement in prison. I just want you to let that soak in for just a moment. You understand where you stand here on all of this. You've got 117 days credit. That's far short of being able to be paroled. You'd have to stay in there a long time. Now, what we're going to do is grant your attorney's request. I'm going to suspend this, place you the confinement, place you on probation for 10 years. Do well, it'll get shortened. But you have a lot of requirements to do in this probation, not the least of which is make sure you are always properly complying with the requirements for sex offender registration, and because that'll get you quicker revoked than anything else. Also, there will be terms and conditions of probation, which are normal and customary for this type of offense. And you will register with the sex offender tracking program. You will also enter and successfully complete a moral recognition therapy class, which is a good thing all the way around for all people. But you and I both know what the background of this case is and why you were registering as a sex offender. And we're not going to, there's no reason to ruin everybody's day about it, but it's not a good thing. That was in the past. What's in the past, though, it said is never really ever in the past. You got to deal with it on situations such as this. Also, you must understand that this is a conviction here, even though you're not going to prison. This is your second felony conviction. Third one is catastrophic for people. So you've got everything to work for in successfully handling this probation. Get this back on the deferred. Give it to Rogan so she can shred it really fast. Well, that one probably do more harm, I would think. That deferred. If you will revoke on that deferred, you'd be looking at up to 20 years in prison. So this, you're capped at 5 years, but nonetheless, you know what it's like. And this gives you an opportunity to take care of concrete work, get a trade, follow the rules, and stay out of trouble. Are you going to be able to do that? Good. All right. Just don't talk the talk. Good for you. Walk the straight line. All right. Please, we're gonna get your thumbprint, then please see the probation officer. Thank you.
Saying 2 more times, just anywhere.
Next, you want to pick up?
Harris, Nehemiah Harris. Judge, this is clearly an old case, but
I'm an old case.
she was not in the county until recently, Judge. I'm still working on getting her discovery for media and talking with Mr. Boyd. If I could have 2 to 4 weeks to get everything ironed out with.
All right, we set 3.
Yes, 3 weeks. Thank you.
It's an empty enough change, you know.
Yes, I have not. I don't even have a court discovery just yet.
Okay.
Colton Fall.
We were holding him, Judge. I need to go through some paperwork.
Okay, and Kendrick Franklin.
Just still talking to Mr. Boyd about that one.
And then I've got Heather Lane.
Yes, Your Honor, she is new to me. I still don't have her media. If I can have 4 weeks on her,
You
please.
got 4 weeks resetting on Heather Lane, on 25 CR 655. Benjamin Leonard.
Same thing on him, Judge. I
You
need
need
2
some time?
weeks for media.
Okay. Blake Ritchie.
I need to hold him. That one might be a potential plea today as well.
And
Judge. And then we have Keith Pruitt.
Finally, we did Christopher Smith already.
Yes, that's correct, Judge.
What?
Keith Pruitt, he's the one with the letter from the Texas Health and Human Services. We need to
Okay.
get findings from him.
All right. Do we need him out right now?
I don't think he's not here. Just not here.
It's not a waiver, Judge.
You'll have to put on the record.
All right, let me put this, here it is. We now call 236015, the state of Texas versus Keith Andre Pruitt. Ms. Manalden, defendant's attorney, is present. The defendant is not here. Do we need him here in person on this particular matter? All right. Can you summarize here on the record what we're going to do? Because I have in the file received a letter from the Texas Health and Human Services Commission dated July 3rd, 2025, a month ago here, regarding Mr. Pruitt. And essentially, they're stating that the defendant needs continued ongoing inpatient treatment toward regaining competency, and that's why we haven't moved him around the country.
That's correct.
We're we're keeping him in that place because that's where he is progressing, apparently, according to these authorities. And it states here in a letter from Sylvia Trevino and also signed by Sonia Hernandez Keeble, the trial competency analysis is Ms. Trevino, and then Ms. Keeble is the superintendent at Texas Health and Human Services Commission, and they have the cover letter requesting additional time of treatment for Keith Pruitt. And there is a 6-page trial competency evaluation that is attached to this cover letter. And I'm going to call the cover letter dated July 3rd, 2025, and the 6-page competency evaluation report, court's exhibit 1 for this hearing. Any objections?
No, Judge.
No, Your Honor.
Do the parties want to add anything to the record here?
No, Your Honor.
No, Your Honor.
All right, in summary, the defendant is diagnosed with a bipolar type of schizoaffective disorder, presents symptoms of mania according to the report. And it is of the opinion of the authorities that with appropriate treatment, he can attain competency within the foreseeable future. He has not responded to multiple medication trials, but he is starting on a new antipsychotic at this time, which may be effective according to the attendance authority. Thus, their recommendation is that he be continued in his current competency restoration program. And this is also signed by Dr. Moron, Moron, ND at the Rio Grande State Center. So this is all made of part of the record in this case. How long should we, it is renewed, how long are the parties recommending that this be renewed?
I think AC so.
I think since this is a renewal,
I'm going to renew it, but I think I have to set a not to exceed period of time. I don't, but they're not giving me
it doesn't show
a real
what they recommend.
designated time period here.
I think it's yearly, Judge. Yes, I do think it's.
You're not sure on competency. That's what I was checking.
Or we could do 6 months if that's. But I mean,
I thought it was 6 months. Generally,
With insanity, it's a year, so I think it's 6 months on competency.
great.
okay, the court will order the defendant for continued treatment, not for a period not to exceed 6 months unless the Texas Health and Human Services evaluators and treating physicians and treating attendants submit to the court a written document suggesting otherwise. How's that?
Sounds great. Judge.
We will have an order prepared here with the court's findings and that the defendant is still mentally incompetent and continued treatment is necessary toward gaining the defendant's competency. Okay. And for a period not to exceed 6 months. Thank you.
Thank you, Judge.
Okay, next.
I have 3 that are held.
Good,
I need
okay.
time to work on those.
Okay.
Thank you, Judge.
Langston, you got some things?
Yes, sir. I'm signing one up as we speak.
We're in a short recess, Stand by, please. Thank you. In the amount, do you understand?
Please do.
Ramsey?
Yes, sir.
It'll be Richard.
Yes.
Frank Ramsey, I believe. Yeah.
Please do. And also, Devalier is done.
Devalier sounds French.
I believe.
I think it's Devalier. I grew up with the Devalier. We've got Richard Ramsey.
Yes, sir.
In front of her first, please.
Yes, sir.
Thank you.
I need your right down.
You want me to get the whole thing for through?
Yeah.
Let me get it.
Straight up and down. Okay.
Well, let's,
Two more thumbprints.
we'll get them going while we're doing this, please.
Yeah, don't roll.
It's all good. Richard Fleischer. Yes. Yeah.
Thank you.
Yes, ma'am. That's it.
Yes.
Yes, ma'am.
24 CR 1777 is now called the state of Texas versus Richard Frank Ramsey. That's you, sir.
Yes, sir.
Present with your attorney, Mr. Adams, and the state's attorney.
Yes, sir.
Does the defendant waive a formal reading of this indictment and the arraignment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about June 19th, day before my birthday, 2024 in Jefferson County, Texas, you committed the state jail felony of theft. Do you understand what you are charged with here, sir?
Yes, sir.
If convicted of a state jail felony, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached where you would be, is that your signature?
Yes, sir.
It's a dramatic signature. You would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 5 years in length.
Yes, sir.
We can shorten it to 1/3 if you do well.
Yes, sir.
Restitution is owed in the amount of $800 to the complainant in this case, Royce Hill. Do you understand the plan here?
Yes, sir.
There'd be terms and conditions of probation, which are normal and customary for this type of offense.
Okay.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty?
Yes, sir.
Stand by. Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
And without objection, it's admitted. Among other things, this states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer.
Yes, sir.
All of this is true, so help you God.
Yes, sir.
State's Exhibit 1, made a
No
public record without objection. I'm going to follow this agreement and find you are indeed mentally competent to enter your guilty plea, which is freely and voluntarily made. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. So long as you follow these terms and conditions of probation, which will place you on deferred or unadjudicated probation for 5 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You will complete a theft prevention class.
Yes.
There would be other terms and conditions of probation, not the least of which is restitution is owed in the amount of $800 to the complainant, in this case, Royce Hill.
Yes.
And how long would it take to get that restitution paid back?
Couple of weeks, month tops.
I'll give you 4 weeks, okay?
Yes, sir. Yes, sir.
Restitution
Yes, sir.
to be paid in 4 weeks. Have you ever been convicted of anything before?
Yes, sir.
You have? What was it?
Controlled substance.
Is that all fixed?
Yeah, yes, sir. Everything's just good. This is
All right.
fix.
All right, well, fix this one.
Yes, sir.
Okay,
Yes, sir.
all right, sir. Please see the probation
Thank
officer.
you.
Thank you.
Thank you, Joe. Thank you. Good luck with this. Yes, sir. Appreciate it. Thank you.
You know what's bad about this pad is these pads, it's the curse of the left-hander because of the way I write, if you put your hand
Heat from your hand.
on the pad, it'll smudge the pad and.
You're gonna have to change directions.
Yeah, okay,
The other
that
guy,
was Mr. Ramsey. You have Jay DeVillier,
he's ready.
Jay DeVillier, please.
And he just needs to be fingerprinted.
Okay.
Okay. He's good. He's good.
We didn't have that on, but I don't know if he has, but no. Where they are, in case you go out, some notes down, who gets files, so you can some. Okay, all right, this. Yeah, thumbprint?
Yeah, please.
Really good discuss on that one. Yeah.
Same stuff anywhere.
Pretty honest. Good on which one? Richie. He's ready. On the radar.
We now call 25 CR.
We always do that.
Right there, sir. 25 CR 729, the state of Texas versus J. Kenneth DeVillier. You are Mr. DeVillier, present with your attorney, Mr. Adams, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
Hold on for a second. In summary here, this alleges in this indictment that on or about May 5th, 2025 in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon, namely a broomstick. Anything is capable of being a deadly weapon if in the manner of its use is capable of causing serious bodily injury or death. So this is
The second degree, Your Honor. I'm sorry if the paperwork may have been here.
You've already gained a reduction in your charge here to a second degree here. This is a second degree felony, which means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? Agreement has been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years. Do you understand? There's no fine here, but there would be terms and conditions of probation which are normal and customary for this type of offense. You understand?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand that?
Yes, sir. What? There's one. Can't you speak up? I'm an old man.
I got problems here. This, gorgeous, look.
Okay.
This is not working at all. They need to come down and we can't get our business done.
To keep switching them, they got like that.
I mean, there's no.
You feel very. It's like. Being here. Showed up early and he disappeared. I thought the sun was coming up, it was just to say, no, it's just this.
It won't write when you try to write on it, but if you touch it, it makes a mark. But using the stylus doesn't work at all.
Yeah.
There. This is not working.
This one's just here, he's gonna get 30 to Charleston and up, so. Yeah, okay.
Got charged it low. Here, just exit out.
Yeah.
That's more. No, say no changes.
No changes.
This, see, it's just,
I know.
this is supposed to be the new and better things and.
They're coming in
At
October.
all.
We're stuck with these.
At all.
for just a few more.
At all.
New one's coming out.
Yeah.
So that's good.
The Dell ones are finally gonna be here.
So the Lowe's is going to the jail, huh?
Well, I don't know. I kind of feel like we shouldn't. So it's there, but. That's your hand.
I know, but I can't write without putting my hand on it. Okay, I figured it out. Well, out with the machine. One way or the other. How do you plead to this, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty? Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct? Yes. You have to speak out. So she can. Yes. Okay. State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. This states you are mentally competent to enter your guilty plea, which is freely and voluntarily. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of this crime and any lesser included offenses. You were giving up your right.
Issue, but it hasn't come up again in indictments.
For sex offender registration, and because that'll get you quicker revoked than anything else. Also, there will be terms and conditions of probation, which are normal and customary for this type of offense. And you will register with the sex offender tracking program. You will also enter and successfully complete a moral recognition therapy. With the indictment's been read to you, you've read it. You are guilty of this crime and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All truth so help you God. Yes. States Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I am going to follow this agreement, if nothing further. I'm going to find you, sir, pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from States Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt right now. I am not going to do that. I'm going to rather place you on deferred or unadjudicated probation and postpone any finding of guilt so long as you follow these terms and conditions of probation. They're normal and customary for this. To fix this, we can release you from these requirements in a third of the time. But if you fail, which is, I hate talking about this, but I have to tell you, if you fail, your probation could be revoked. Yes, sir. You could then be found guilty and sentenced for this up to 20 years in prison. So there's a lot on good behavior writing on this. Fix it. Anything else to add by anybody?
That's it.
Okay, please see the probation officer. Good luck.
Hey, Judge, on Mr. Herring, I just want, no, he's not Mr. Herring. You can good luck. I just want one reset on him, and I'll try to work that out. I just need to investigate a little bit more. So I just had 3 today. He's the middle base.
Yeah, Mr. DeVille. Okay. Nathan Herring, how much time?
Just normal 4 weeks.
We don't have anything normals here. Is 4 weeks good?
That's cool.
Okay. Okay. Thanks.
And she's working on the plea.
Yeah.
We got it done. Okay. Work shit on.
Yeah, we got to keep moving them. Oh, well,
And she-
at least if I call on hers.
I'll be done. See what kids. Well, pretty nothing.
Sounds like a song.
I know. I know they're gonna. Yeah.
All right, above that.
That's wrong, sorry.
Yeah, right, yeah, that's what I understand. There's a brand. Wait, let's talk about that for a minute.
Hey, Billy, hey, how are you? Good.
You know, it's okay. This is down. Thank you, big brother.
Always down.
Did we do Clarence Small already?
That's just that right.
Okay. Okay. All right. I was wrong. Okay. So I've got something in the queue on Richie, Blake Ritchie. Then she's got Colton Falk, Kendrick Franklin, and Keith Pruitt.
We did Pruitt.
We did Pruitt.
Renewals like no pleasure. Are they correct? But more reasons.
Yeah, I don't know where she got that from.
Okay, we've got,
Like Richie's.
Blake Ritchie, Colton Falk, and Kendrick Franklin. Nobody's listening to me because
Very nice.
I feel like I'm at home.
Richie, he's ready.
Blake Ritchie,
Yes, Judge.
and then we have Colton Falk and Kendrick Franklin.
I'm
I'm
sorry.
interrupting y'all. I'm sorry.
We're still,
And Colton and Kendrick.
Kendrick Franklin, we are in discussion about how to resolve that. If we could have 3 weeks, 3 or 4
Is
weeks.
that what you want?
Sir, we're gonna look at the video, Your Honor, and we will have.
Is 3 better than 4?
3
Yeah,
Are you gonna be in trial?
I'll try and look at it today, so I think.
Okay.
3 weeks. Kendrick Franklin, reset 3 weeks of the request. What about Colton Falk? We're gonna need him.
And Judge, if I could.
Okay, let's get then Blake Ritchie.
Mr. Devine.
I was not giving anything else. Who is it you want?
Jay Devine.
The value her. Mr. DeVille.
Jay Devine.
It's the value.
Builder.
That's good.
Yeah. His name's, yeah. For sure. Yeah. Thank you. I'm gonna need his thumbprint.
Proceed her first. Thank you.
Right now, stamp it, right, instance. I think you need 2 more. Well, restamp it, just let's say.
More than that 2-year-old, we're sitting there going, wow.
Okay, I have Nathan Herring, Michonne Herring,
Yeah, I'm gonna reset this, it's for reset on us.
John Dixon.
We reset his judge.
We reset him. Let's make sure. Kendrick Franklin
We reset him. Just ma'am.
and Nehemiah Harris,
She was reset as well, Judge.
Heather Lane,
She was reset as well.
Benjamin Leonard.
Him as well.
I have Blake, and then I Colton. 25 CR 90 is now called the state of Texas versus Blake Jerome Ritchie. That's you, sir?
Yes, sir.
Present with Ms. Minaldi, your attorney and the state's attorney does the defendant waive a formal reading of this indictment and the arraignment here. Can we proceed in summary?
Yes, sure.
In summary, this indictment alleges that on or about December 10th, 2024 in Jefferson County, Texas, you committed the 2nd-degree felony of robbery. Do you understand what you were charged with here?
Yes, sir.
If convicted of a 2nd-degree felony, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir. That's fine.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 10 years in prison. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'm going to show you what's marked here, State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into
No
evidence.
objection.
Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial
Yes, sir.
and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. A pre-sentence report is hereby waived.
Yes, Judge.
I'm going to follow this agreement And fine, sir, you are pleading guilty to this second-degree felony of robbery voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. You are also giving up your rights to a jury trial and the rights to the appearance, consultation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer, and you are expressly stating flatly that you are guilty of this crime. I now find you guilty beyond a reasonable doubt of the second-degree felony of robbery. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years, and you will be given credit for all time toward your service. This is not an affirmative finding, so you're parolable in a quarter of the time served. Anything else?
No, you're.
That is all. Thank you. Good luck. Yes.
And Judge, you need a moment with Mr. Cole and help.
Thank you. Yeah, man.
But okay. You figure that's it. I'm just on there. What about a video? Yeah, a mother was. You have I'm in. I'll be back. It does. I hope you have one of those. My money's in it. So I don't.
Yes.
So. Checked. She's doing the full right here, which I'm getting. The last one, in somewhere. So. Gotcha. Okay. Moving off of that thing. Moving on. It's just. Oh, you'll like. It was in the
Correction, controlled substances, assaults, not being at home, committing criminal mischief, and failing to report. So, I mean, those are.
I hear you, Judge.
All right. Well, I think he's entitled to a bond, but it's
It is because it's on the.
but it's going to be astronomical. All right. Bring him out, please. I want this hearing to get this. We're going to move this up with fireworks and get this through. 19-31683. You said this for 2 weeks, so we can get this done, please. Are you Colton Chase Falk?
Yes, sir.
Yeah. You were here with your attorney, Ms. Manali, and the state's attorney. You understand you were charged with a motion to revoke unadjudicated probation, being on probation since February 10th of 2020 for the first-degree felony of aggravated robbery. Then you've got allegation of committing criminal mischief on or about February 5th, 2025 in Orange County. Then the next day, criminal mischief in Orange County on or about February 6th, 2025. Family assault, violence on or about March 29th, 2025 in Orange County. You tested positive for cocaine and amphetamine on May 6th in a urine sample with the probation office. Failed to provide verification of performing community service hours as required at a location other than your residence at 12:30 March 29th, 2025, which is when I guess this assault family violence was happening on that day. And that's in violation of your probation order. Failing to pay court assessed fees, you're in arrears on failing to pay, and then failing to report to the probation office. As this states, you failed to report by mailing in or online for September, November, December, and as directed in violation of your probation order. So those are 8 separate violations. It only takes one to revoke your probation. And you are looking at first degree felony, if you're looking at the life in prison, do you understand?
Yes, sir.
I thought, I do remember the circumstances of this case, and these are very disturbing circumstances. The underlying crime, I mean, the man was an elderly person who's disabled that you assaulted at a bank when he was trying to get some money from his limited income, which was terrible set of facts, terrible. And then this happens. Well, I want a hearing on this in 2 weeks. All right. And you're asking for a bond?
I am, Judge.
Go ahead. Tell me. I see the motion here, and the flight risk. I don't know if he's a flight risk or not, but I do know he doesn't show up when he's supposed to, or report as directed. Those are allegations, and it's just 1, 2, 3, 4 crimes are being alleged here on this court's watch, including this cocaine and amphetamine possession positive on that urine sample. And then really these reports not reporting. If you don't report, you're not on probation. You're on your own probation, which isn't the way it works. But what's they asking?
Your Honor, just because of the, just danger to the community, the individual assaulted, he's still married to that individual. We're obviously concerned for her safety. We would not be in agreement with the bond. And if there is one, that it be sufficiently, high to.
What do you think is sufficiently proper under these circumstances?
Your Honor, I'd ask for 150,000.
I think that's too low.
Yes.
So it's 250,000 is your bond. Plus, you have to have a GPS. You have to be on home confinement. You're free falling. Might watch on a first degree felony with the underlying circumstances being so aggravated. And then you're testing positive on drugs, assaults, curfew violations. Is that right? Yeah. And not reporting like you're supposed to. How many things can go wrong here? No. We're going to have a hearing. I'll deal with it. Everybody gets to sound in, but we're going to do this in 2 weeks, and for certain. You understand?
Yes.
Okay. And then the court will make its rulings. Everybody get ready to present so that I can have the most informed decision. But this is disappointing, to say the least. There are other words that are more useful, but anyone on these types of facts for a violent crime like this, one problem is enough. Here, crimes of violence alleged, not reporting, drugs. I mean, we're not talking about marijuana, which is bad enough. We're talking about cocaine and methamphetamine or amphetamine. You're free falling, sir. You should have caught yourself. Your probation office, we have a 93% success rate. That's 1 in 14 failures. Probation, which is a fabulous. We're very proud of that. You're the one who's got a motion to revoke probation. Of the other 13 out of 14 probationers never get that. And these are serious charges. the rhetorical question is why? You have the benefit of probation. You know, we made a big deal about this in the first place. What's wrong? I'm just rhetorical. I don't want you to answer. These are questions that I want at this hearing to be answered. Why have you failed? If this is true. But these are terrible. Maybe there's a good reason. We'll hear it. But we'll see you in 2 weeks. Okay, that's all. Counselor?
Are you?
Yeah. Yes, I am.
You have to start your video. Ms. Ellis, did you listen to and understand the rights in the video? Did you listen to and understand the rights in the video, Ms. Ellis, or she disappeared? I can't see her now.
Yeah, it looks like we've lost her, Your Honor.
All right, South Point Square.
Do we say Riverside versus Bellamy, Judge? Is that?
Riverside versus Bellamy and Guess. 2502957. All right, Mr. Modar, your appearance.
Max, you have Modar on behalf of plaintiff, Your Honor.
Mr. Guess.
Zacharias Guess.
Mr. Bellamy.
Xavier Bellamy.
All right, now. The total balance is 1,605. Do you agree with that, Mr. Guess?
Yes.
Mr. Bellamy?
Yes.
Have you limited late fees to 70 per month, Mr. Modar?
I have limited late fees to 70 per month, and in fact, I went and removed $80 from the balance that was previously stated simply based on there being a charge on the ledger of $150 in late fees in 1 month. While it's not a month that I believe we're here for at this time, it was still addressed and updated. So now the balance that I've got is $1,520.05.
All right, give me your total breakdown then again.
Hello?
So we've got the rent to retain on this one being $1,341.05. Court costs in the amount of $179, giving us our grand total here today of $1,520.05. There is only one charge of late fees now on this ledger, and that charge is in the amount of $70, Your Honor.
All right, did you, Mr. Bellamy, you agree that's what you owe?
Yes, Your Honor.
Mr. West?
Yes, Your Honor.
All right, so you're just seeking the judgment after hearing, correct, Mr. Modar?
So we've agreed to the terms of a consent judgment on this one. We're providing until August 15th of 2025. I would like to make note for the record, we do have language in this agreement that indicates that there was a payment, or that defendant indicates that he made a payment of $100 not yet addressed on the above balance. I don't disagree with that indication. I just don't have that on my ledger here today. I do have permission from both Mr. Bellamy and Mr. Guest to add their signatures to this resolution, and we did go over MCR 4.201J.
Is that true, Mr. Guest?
Yes.
Mr. Bellamy? Mr. Bellamy?
Yes, Your Honor.
All right.
Yes, it is true.
So you agree that you owe 1520.05, There is an indication you paid, one of you paid or both of you paid $100. He's going to put that in further order so that if that check clears, assuming it to be a check, the balance would be removed or lessened by $100, leaving a balance of $14,2005, which you would have to pay by August the 15th. If you don't, you will be evicted if you haven't vacated. Do you understand that? And agree to that, Mr. West?
Yes.
Mr. Bellamy?
Yes.
You have 3 business days, gentlemen, to fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that, Mr. West?
Yes.
Bellamy?
Yes.
And does Mr. Mudar have your permission to sign your name to that document, that proposed consent judgment? Mr. West?
Yes, Your Honor.
Bellamy?
Yes, Your Honor.
All right. I wish you well, gentlemen. Did I cover everything adequately, Mr. Mudar?
I believe so, Your Honor.
Okay, so you guys are all set. Just make sure you pay up by the 15th or else you're going to have to vacate by then. Okay, thank you. Good luck.
Thank you, Your Honor.
What else do you have here that would be ready to go, Mr. Mudar?
I'm ready on all of South Point Square Apartments hearings.
I'm going to
I
take,
believe I've got one with JMZ.
right, I'm going to take, let's see here. Mr. Cassers, David Casser versus Ramika Ellis, 2502952. Is Ramika Ellis out there?
Yes, I'm here.
Your name, ma'am?
Regina Ellis.
Mr. Casser?
Good morning, Your Honor. David Kessler.
Ma'am, did you listen to and understand the rights on the video?
Yes.
Do you wish to speak to a lawyer?
No.
Do you intend to apply for funding?
I've already applied.
When did you apply?
I applied 2 weeks ago now.
Have you heard from them?
I did recently hear from them, and
Your Honor.
just because I work at the hospital, they denied me. I was on medical leave
Okay.
for my foot.
So you've been denied the funding, correct?
Yeah.
Mr. Casser, give me a breakdown as to how much is owed, please.
Your Honor, this is a termination case. There's
Oh.
no money involved.
I'm sorry. I'm sorry. My apologies.
Thank you.
Why don't you have to leave, ma'am?
I'm sorry.
Why don't you have to leave?
You said, why don't I have to leave?
Yes. He's not
Oh,
suing money. He's suing just to get you out. He has the right to do that if the lease is expired. Has the lease expired except for a month-to-month provision, Mr. Casser?
We're on a month-to-month agreement from the beginning, Your Honor.
So why don't you have to vacate, Ms. Ellis?
Well, I do have to vacate because of the rent is not paid. I haven't been able to make payments due to the fund.
He's not seeking to have you removed for non-payment of rent. He's seeking just to terminate the tenancy.
Right, and I believe that's because of the money owed. It hasn't been paid.
So all right, what are you asking me for, Mr. Casser?
I would like to have the written 10 days, Your Honor.
Any reason you can't vacate in 10 days, ma'am?
No, I'm actually in the process now. I just needed the time to get everything out.
All right, writ date after hearing, August the 14th. That's judgment in favor of the plaintiff. You can submit that order, sir. Okay, August 14th. Thank you, ma'am. I wish you well. You have to vacate by that date or else you're going to be evicted, okay?
Yes, absolutely.
Good
Thank you.
luck. Thank you.
Thank you.
Thank you all. Thank you.
Thanks. South Point versus Daniel Abrams, 2502958.
Maxfield Mood on behalf of plaintiff, Your Honor.
Good morning, Mr. Abrams. Your name, sir?
Daniel Abrams.
Mr. Abrams, did you listen to and understand the rights on the video?
I did.
Do you wish to speak to a lawyer?
No.
Do you intend to apply for funding?
I don't think that's necessary.
Counsel, give me a breakdown as to what's owed, please. So we've got a rent to retain on this one in the amount of $1,158.80. Court costs the amount of $179, giving us our grand total here today of $1,300.
Where's the late fees? I thought you were going to give me a breakdown. That's what I was trying to ask you nicely. I don't want to. I need a breakdown. I need rent to retain, late fees, court costs.
Okay. So the rent to retain, once again, being that $1,158.80. The late fees, there was one charge in the month of July of $200 that was dropped down to $70. $130 was removed from this balance, has already been applied to this judgment.
Hang on. They're charging $200 in late fees?
For the month of July, they charged $200. A $100 charge on the 7th and another 100 on the 16th. It looks like they believe that there's 2 charges of late fees.
That's pretty good. I'm going to become a realtor. I mean, I'm going to become a landowner here. That's like 18% a month, right? The rent's that. So let's start over. Tell me what the rent to retain is. That's all I want to know right now. What's the rent to retain?
The rent to retain is $1,158.
I thought you said that included late fees.
No, that includes the late fee removed of the 130. And so it's dropping down the late fee to the 70 that you have requested here, Your Honor.
I know. So listen, so if you're charging a late fee of 70, then in my view, it should be $1,088.80 in past due rent, right? That's all I'm asking you to do is tell me rent to retain, then the late fee of, then the court costs. So am I right? The $11,858.80 includes a $70 late fee. That's what I was trying to say before. I don't want to just hear and then have to go through this on the late fees.
Okay, and so then you're absolutely correct. Prior to that $70 late fee being added, it'd be $1,000 or $1,088.80.
All right, now what is the court costs? 179?
Correct, 179.
Total amount is?
Would you like the late fee added in or no?
Yeah, the total amount owed. I want first rent to retain, $1,000 a month, they pay $1,000. Late fee 70. Court costs including attorney fees, whatever. And then add them up. That's all I'm asking.
I gotcha. And so that gives us a grand total then of $1,337.80.
You sign a lease, Mr. Abraham, saying you're going to pay $200 in late fees if you don't pay that. You got to be careful. You got it? I'm just saying.
I don't know.
Do you agree that you owe $1,337.80?
With those, I thought it was less than that. I
know, but come on. There's only one.
That's a lot of late fees.
One answer. That's the great thing about it. It requires no lawyering. None, zero. The figures are what they are. Do you have any reason to dispute that amount? If you do, tell me the exact amount that they owe you. Then we'll talk.
I have.
That you owe them, I should say. Mr. Abrams.
Yes, I'm looking at my paper. I'm sorry. Okay, so I thought I owed $1,158. Is that not right?
Does that include late fees and court costs?
I thought that included everything, but.
Well, then you give me your figures. You tell me how this turns out.
You have 1,000 what?
He says you owe $1,188.80 in past due rent, a late fee of $70, in court costs, including a $75 statutory attorney fee in the amount of $179, and adding all those up becomes the $1,337.80.
Okay. Yes, that sounds right.
Oh, so do you understand? Do you have that money to pay?
I don't have it today. I do not.
When are you going to have it?
But I can have it by the 25th of this month. I can have everything.
You're asking for a lot. They're entitled to a writ date on the 14th. How much can you pay on the 14th?
The 14th. Well, I can pay at least. I can pay $600 by tomorrow. By the 14th, yeah, I'm on unemployment. I should probably just, I should probably try and get, funding if I only have till the 14th, because I can't pay it by the 14th. I'm collecting unemployment right now, the 25th. That's
600 by August 14th. Are you willing to give them until the 25th? If
Yeah,
not,
that's not a problem, Your Honor.
okay, so if you pay 600 by August 14th, the writ date will be extended until the 25th, okay?
Okay.
So so the judgment amount is going to be 1337.80. It's going to say right on there, and it's going to have a writ date of August 14th, but it's going to say with an asterisk, if the defendant pays $600 by August 14th, writ date extended until August 25th. You have to pay the remaining balance or vacate if you miss either one of those dates. Do you understand that?
I did. The 25th is a Monday. Can you give me until the 26th, please? That's one day. I certify on. Yes, thank you. I appreciate that.
26, no later.
Okay.
All right. Good luck.
Thank you. Thank you, guys. I appreciate it.
South Point versus Gilmer. Akiva Gilmer. 2502964. Ms. Gilmer, your name?
Akiva Gilmer.
Good morning. Did you listen to and understand the rights?
Yes, Your Honor.
You wish to speak to a lawyer?
No, Your Honor.
You intend to apply for funding?
I did, but I just recently did it a couple of days ago, and I was on the phone with them before I got on the call with you. So right now it's just waiting to know
You
whether
applied
it's
for
going
funding?
Yes, I did.
You haven't been denied or heard anything yet?
No, I talked to them this morning on the phone. I had a phone call.
Just answer my question. I'm going to adjourn this to August the 18th.
Okay.
You have to provide proof that you submitted your application for funding within 5 days of today's date.
Okay, but can I ask you one more question?
Ma'am, you have to bring it up here to the courthouse. Okay? Do you understand that?
Yes, Your Honor, but I was going to ask you one more question if possible.
Go ahead.
Because that was not the initial behind the funding. I was going to see if we can reach a judgment.
Wait a minute.
Because I had a note on my...
Hang on. Did you apply for funding or didn't you?
I did, but I didn't know how fast it was going to go. So I was trying to see if I can go off of the balance that I had on my door when I came home for work Friday, which was a balance of $706.27. And I was trying to see if I could pay that Friday because I will have that by Friday.
Is that what she owes, Mr. Mudar?
No, that's not incorporating August rent, unfortunately.
That doesn't have August rent, ma'am.
Oh, okay.
Listen, I'm adjourning this to August 18th. Jennifer, at what time?
9 o'clock.
At 9 o'clock. You have to provide proof that you made application for funding within 5 days.
Okay.
If you do that, we're going to come back the 18th and find out what happened. Okay? So I'm adjourning this date, August 18th at 9. You have to submit proof to the court that you made your application for funding within 5 days. Do you understand that?
Yes, Your Honor. Do I bring it up there to you or how do I?
Not to me, to the civil department, correct.
Okay.
Okay? Good luck. South Point versus Robert Johnson, 2502965. Mr. Johnson, name?
Your Honor, I have not had Mr. Johnson check in.
You can take a default on this one, counsel.
Max Field Mudar on behalf of the plaintiff, Your Honor.
Go ahead.
So we've got a rent to retain on this one. Would you like me to remove out the late fees and provide the late fees as well? We've got a rent to retain on this one being $3,312.81. We got court costs.
Wait a minute. I want the late fees stated separately so the thing doesn't happen. I'm not trying to give you a hard time. I like you. You're a good kid. You've been in here before. But like the last person that was trying to charge $200 or this company, they're not doing that. They're not doing that. I'm going to make sure by making you guys tell me what the late fees are. And if I find out they're doing that and adding those, I'm telling you, the manager will be here every single landlord talk a day for the rest of my days here. So just tell me what the rent to retain only is right now.
Understood, Your Honor. My misunderstanding. So what we've got on this one is we've got a rent to retain being $3,172.81. We've got late fees in the amount of $140. That's $170 late fee coming from July, $170 late fee coming from June. We've got court costs in the amount of $179, giving us the grand total that we're here for today of $3,491.81. And then we've got a writ date on this one of August 14th, 2025.
Defendant failed to appear. Default judgment will enter. Writ date will be August 14th of 25. 349182 is the amount to be paid to save it. South Point versus Ashley Minter, 2502968. Your appearance?
Max Fieldmutter on behalf of plaintiff.
Is Ashley Minter here?
No, Your Honor.
Second mailing was paid for. You can take your default.
Thank you, Your Honor. Plaintiff moves for the entry of a default judgment. We've got a rent to retain on this one in the amount of $2,872.42. We've got $70 in late fees, court costs being $179, giving us our grand total here today of $3,121.42.
Defendant failed to appear. Default judgment will enter. Writ date will be the 14th of August. The amount to be paid to save it is $3,121.42.
Thank you, Honor.
South Point versus Cherokee Myers Jennings and Gregory Mercer, 2502969.
Your Honor, I did not have defendants check in.
You can take a default on this one. There was a second mailing paid for.
Max Fieldmutter on behalf of plaintiff, Your Honor. At this time, plaintiff moves for the entry of a default judgment. We've got a rent to retain on this one in the amount of $1,965.99. Late fees in the amount of $70. Court costs in the amount of $179, giving us our grand total here today of $2,214.99.
Defendants failed to appear. Relief request will be granted. Default judgment possession in favor of plaintiff against defendant. Writ date, defendants. Writ date will be the 14th of August. The amount to be paid to save it is $2,214.99. South Point versus Fredetia Nicholas, 2502970.
Max Fieldmutter on behalf of plaintiff.
Your Honor, I did not have defendant check in.
You paid for a second mailing. You can proceed.
Thank you, Your Honor. At this time, plaintiff moves for the entry of a default judgment. We've got a rent to retain on this one in the amount of $1,328.01. Late fees in the amount of $70. Court costs in the amount of $179, giving us our grand total here today of $1,577.01.
Defendant failed to appear. Default judgment will enter. Writ date will be August the 14th of 25. The amount to be paid to save it from the issuance writ is $1577.01. South Point versus Monat Williams, 2502971.
Max,
Your Honor, I did not have
plaintiff.
Defendant did not appear.
All right, you can take a default on this one.
Sorry for interrupting you there, Jen. Max Fieldmutter once again on behalf of plaintiff, moving for the entry of a default judgment. We've got a rent to retain on this one in the amount of $3,074.27. Late fee in the amount of $70. Court costs in the amount of $179, giving us our grand total here today of $3,000. $323.27.
Defendants failed to appear. The relief request will be granted. Default judgment in possession in favor of plaintiff and against defendant. Writ date will be August the 14th. The amount to be paid to save it is 3323.27. And that is it for South Point. What other ones do you have now, Mr. Mudar?
Your Honor, I believe I've just got one last one with plaintiff JMZ.
JMZ Management versus Stacy Moore, 2502975.
Max Field Muda on behalf of plaintiff.
All right, is Stacy Moore here? Are you Stacy Moore? Come up to the podium, ma'am. Did you listen? State your name.
Stacy Moore.
Did you listen to and understand the rights on the video?
Yes.
Do you wish to speak to a lawyer?
No.
Do you intend to apply for funding?
No.
Give me, just right now, all I want is the total balance. You don't have to go through all that right now. Just tell me the total balance.
So the total balance that I showed today is $6,694.
Ooh. You better give me the breakdown now, okay? Rent to retain is?
So we've got a rent to retain on this one being $6,305. We've got 3 late fees from 3 separate months being $70 each, giving a grand total of $210, which then adding in the court costs of $179 gets us to our grand total of $6,694.
Do you owe that amount?
Yeah.
Can you pay that?
I can get it paid today and tomorrow.
I'm gonna give the judgment for plaintiff after hearing, and that's gonna be for 6694, and the writ date's gonna be August 14th. So if you pay it today, you pay it tomorrow, you pay it by the 14th, you could stay. If you don't, you have to vacate, okay? I wish you well. Good luck. Thank you. Do I have any more down there? I must. Pardon? You don't have any other landlord tenant?
Your Honor, I believe at the very least.
Water's
that's the last
Edge?
one I've got with you.
What's that?
I believe at the very least that's the last one that I've got with you.
Thanks, you're all set. I've got Water's Edge done, but I gotta go to Water's Edge versus Armstrong and Stewart. Are they here? How about Gibraltar Point? Gibraltar Point versus David Adams, 2502978.
Good morning, Your Honor. Attorney Elizabeth Ellison, PA 2098 for the plaintiff.
Is David Adams here? You can go ahead and proceed with a default on this, counsel.
Your Honor, rent to retain is $2,180. There is one late fee at $70. That is $2,250 total, plus the court cost of $184.17. The balance being $2,434.17.
Then I failed to appear, default judgment will enter. The writ date in this case will be August the 14th. The amount to be paid to save it from the issuance of the writ is $2,434.17. You can submit that. Do you have any more, Ms. Ellison?
I do, Your Honor. I have 3 more.
Which one?
Truman Estates, and there was one more, Gibraltar Point. Wait, no. The Gibraltar Points are done. Truman Estates is the last 3.
Do you have Truman Estates? Anybody?
We should all be up there at 10:30.
I'm here, Dale Rogers.
I don't have Truman Estates up here, guys. Is Hannah Radcliffe here? Let's do that one. Brunswick versus Hannah Radcliffe, 2502979. Ms. Radcliffe, good morning. Your name?
Brianna Kingsley for the plaintiff, Your Honor.
Ms. Radcliffe, your name, ma'am?
Hi, I'm sorry. I was trying to press the unmute. I'm here, Hannah Radcliffe.
Did you listen to and understand the rights, ma'am?
Yes, sir.
Do you wish to speak to a lawyer?
No.
Do you intend to apply for funding?
No.
Do Ms. Kingsley? What do you have here on this one?
I have a total of $1,791.54.
That's including everything.
Yes.
You agree that you owe him that amount, Ms. Radcliffe?
Yes, sir.
Did you pay it?
Can I have until the, is it the 28th?
Give me a breakdown, if you would, Ms. Kingsley.
Yes, Your Honor. Rent to retain is $1,563. Court costs are $178.54. Late fees, there's one $50 late fee for the month of July for a total of $1791.54.
How long do you need? You have to pay some of this by the 14th, ma'am. How much do you, what day are you asking for?
The 28th, only because I started getting garnished and they're taking 25% of my check every week. So.
What do you want to do here, Ms. Kingsley?
Miss Radcliffe, can you pay anything by the 14th?
Yes.
How much?
When is the 14th? Next Friday?
Thursday.
Next Thursday?
Yes, ma'am.
I could probably do 8.
Okay, that's fine. If you pay $800 by the 14th, I'll give you until the 28th to pay the rest.
Okay, thank you.
All right, so if the defendant pays $800 by August 14th, writ date extended until August the 28th, okay? So you have to pay at least $800 by the 14th to get the writ date extended until August the 28th. You understand that?
Yes, sir.
And we're going to do this as a judgment for plaintiff after hearing, okay, ma'am?
Okay.
So make sure you take care of that. Do you have any questions?
No, sir.
All right, I wish you well. Good luck. Thank you.
Thank you.
Tanglewood versus Alicia Shabazz, 250292.
Hannah Kingsley for the plaintiff.
Where is she at? I don't see her out there.
Which case, Your Honor? I apologize.
That's okay. Alicia Shabazz.
There is Miss Rogers, who is an occupant that's present.
Ms. Rogers, your name?
Yes, Jamie Rogers.
Where's Ms. Shabazz?
She doesn't live in Michigan, sir. I'm an occupant. I live here. The house is just in her name.
All right. Did you listen to and understand the rights, ma'am, on the video?
Yes.
I can't hear you.
Yes, sir.
You have to get a little closer to your video there, or to the audio. Do you wish to speak to a lawyer?
Hear me?
Now I can. You got to stay close. Do you wish to speak to a lawyer?
No.
You intend to apply for funding?
No, I already paid the rent today.
Is that true, Ms. Kingsley?
Did you pay everything, including August?
No, I didn't pay August today.
Okay. So I'm thinking, Judge, it was probably just payment of what was due through July. So
You have to pay August too, ma'am. You have to pay August too now, since we're in August. What do you want to do, Ms. Kingsley?
I would seek entry of a possession-only judgment. Do you want my breakdown?
Please.
Rent to retain $1,334.71. Late fees, that's $50 for 1 month. Court costs $189.79 for a total of $1,574.50.
All right, ma'am, can you pay that by August the 14th?
Well, I paid $919 today.
Okay, but I didn't ask you that. You still owe August rent.
Correct.
Can you pay $1,574.50 by August the 14th?
I can pay the remaining balance, but not the $1,574.
So the $1,574 does not include the payment that you made.
So I can indicate in paragraph 10, Judge, that the submission of payment of $919 will be credited to the amount in 2D upon confirmation.
But, excuse me. I spoke with the lady at the front office. The total balance was $1,574. So that would have took my balance down once I just paid this $919.
To $655.50.
Correct.
Well, she's going to indicate on there that that does not include the payment that you made of, you said $919, correct? Ms. Rogers, can you hear me?
Yes, I can hear you.
You paid $919, right?
Correct.
All right, so this $1,574.50 does not include that $919. So the first on the judgment, it's going to say $1,574.50. If defendant paid $919 on August the 4th, then that amount is to be deducted from the $1,574.50.
Correct.
So then you'd only have to pay, what is it,
$655.50.
Yeah, $655.50. Do you understand that?
Yes.
All right, do you agree to that?
Yes.
Okay, so do you want to just submit a judgment for plaintiff after hearing to that effect?
Yes, Your Honor, I can prepare that.
All right, so that has to be paid though, ma'am, that remaining balance by August 14th. You can do that?
Yes.
All right, I wish you well. She'll submit that over and you're all set. Best of luck. Thank you.
Thank you. Thank you.
Your Honor, that is all I have today, so I will see you next week.
Thank you very much. Have a good day. Trenton Grand versus Tesley Ash, 2502987. Is Tesley Ash here? I thought I saw her or not. Maybe not.
Yes, Your Honor, I do have her.
You have to start your video.
I started the video already.
You got to start it again, ma'am. I can't see your face.
Oh, sorry.
And good morning, Your Honor. For the record, Daniel Landman, P35797, on behalf of Trenton Grand and Waters Edge this morning.
All right, ma'am. Did you listen to and understand the rights, Ms. Ash?
Yes.
Tell me your name again.
First name is Tesley, last name is Ash.
And do you wish to speak to a lawyer?
No.
You intend to apply for funding?
No.
How much is owed on this, Mr. Landman?
Your Honor, the grand total is $4,029.35.
Why don't you give me a breakdown if you would?
Certainly. Rent to retain is $3,768.81. There's a $50 late fee. Court fees are $135.54 and a $75 statutory attorney fee.
In total?
$4,029.35.
Can you pay that, Ms. Ash?
So the 3,600.
Yeah, wait. You got to talk to me. You can't look down. I'm not hearing a word you're saying.
Oh, sorry, I'm writing on a pad. I was just writing the amounts down. So the 36, I can make that payment on the 15th and or before, because I planned on making a payment on the 7th. So I've already paid $250. I'll be making a payment on the 7th, and the grand total should be able to be paid by the 15th, which is a Friday. That's a payday for me.
I didn't understand everything you just said. You got to.
I'll repeat it. I got you. So he gave me the total. Sorry if I'm looking down. I'm just looking at the legal pad.
Right.
The total was 4,235.
No.
Okay.
No, 4,029.35.
4,029.35.
4,029. Oh, I'm sorry. I calculated that wrong. So I've already made a payment of 300.
When?
So you'll subtract that. I made that online. So it should have been processed this morning, but it won't come off right now. So I listened to the other young lady. So I'll just keep that as a part.
When?
I paid it on Friday. So it should have been processed through the
$300.
300.
And
So
you're not including
another-
anything made since Friday, right, Mr. Landman?
That's
No, it's
correct,
not
Your
gonna be
Honor.
included
I
yet.
don't have that on our ledger.
All right, so what else? So that would leave a total of 3,729.35, right?
Yes, sir.
When
So
can you
that
pay?
remaining balance I can pay by the 15th of August.
Okay. How about if we just include the 4,029.35?
Yes.
Just say all amounts, the writ date will be August 15th.
Okay, that's
Is that good? What do you think, Mr.
Yes,
Landman?
that's
Fair?
perfect, sir.
The extra day is fine, Your Honor.
Yeah, so we'll give you a writ date of August the 15th. And that's the amount to be paid, 402,935, okay? All right? That will be the writ date. Any questions?
No.
I wish you well. Good luck.
Thank you, sir.
Mr. Lamon, do you have any more?
Yes, Your Honor. I do have Water's Edge
Versus Darren Armstrong and Madison Stewart, 2502986. Water's Edge versus Darren Armstrong and Madison Stewart, 2502986. Are either one of them here? Get this gentleman in.
No, Your Honor, I have not had them check in.
There it is.
I need the lawyer, I need the defendant on Holly, Samuel Holly. Where is Armstrong here or Madison?
No, Your Honor.
Stewart here? Go ahead.
Thank you, Your Honor. Based upon the non-appearance of these tenants, plaintiff moves for the entry of a default judgment for possession only. Based upon my client's books and records, rent to retain is $1,805.94. There are 2 late fees totaling $75. $119.48 for court costs and a
75 total, right? 75 total.
75 total. That's correct. That's correct.
37.50 each.
Yes, Your Honor.
Okay, go ahead.
$119.48 for court costs and a $75 statutory attorney fee for a grand total of $2,075.42. The proposed judgment reflects a writ date of August 14th.
Defendant failed to appear. Writ date will be August 14th of 25. The amount to be paid to save it, 2,075. What is it, 47?
42, Your Honor.
42, sorry. Can't read my own writing sometimes. You are, I believe, all set.
I am, Your Honor. Have a great rest of the day.
Thanks a lot. You too. Do I have any more landlord tenant, Jennifer?
Yes, Judge.
Where are they?
Did you?
I don't know where that.
Well, I had him waiting on too long. Samuel Holly. Well, give me the landlord tenant. Where's all the landlord?
Okay, we have Philip Trofibio, so it would be a folder that says no attorney, and then Truman.
Hang on.
This is a lot of.
Philip Trofibio versus Mariah Stennett, 2502959. Ms. Stennett, good morning. Your name?
Good morning. Hi, I'm Mariah Stennett.
Mr. Trofibio, your name?
Philip Trofibio.
Ma'am, did you listen to and understand the rights on the video?
I did, Your Honor.
Do you wish to speak to a lawyer?
Not right now.
Do you intend to apply for funding?
I have actually.
When did you apply?
So I had to submit additional verifications on July 30th, and those are being processed now.
I'm going to adjourn this to August 18th, Jennifer. Give me a time. You have to provide us with proof that you submitted that application within 5 days.
Absolutely. And you want me to bring that in court in person?
Yes. August 18th at what time?
9 o'clock, Your Honor.
At 9 o'clock. So yes, you have to bring it into court, okay?
Okay, thank
So
you.
we're adjourning this, Mr. Trevivio, until that date, August the 18th.
Okay,
at
sir.
9 a.m.
9 a.m.
Okay.
Got it.
Okay, thank you, Your Honor.
Good luck, thanks. Truman Estates versus John Scheffler, 2502983.
Good morning, Your Honor. Attorney Elizabeth Ellison, P82098 for the plaintiff.
Your Honor, defendant failed to appear.
You can go ahead and take your default.
Your Honor, rent to retain $1,150 with no late fee, plus $184.17 in court costs, the balance being $1,334.17 to be paid on or before the statutory 10 days.
Defendant failed to appear, default judgment is entered, writ date will be August the 14th. And the amount to be paid to save it from the issuance of the writ. 133417 Truman Estates versus Stacy Patterson, 2502984. Stacy Patterson here.
No, Your Honor.
Default judgment.
Your Honor, rent is $960, no late fees, court cost of $184.17, the balance $1,144.17.
Defendant failed to appear, default judgment is entered, writ date will be August the 14th. Of 25. Truman Estates versus Dale Rogers, 2502985.
Good morning, Your Honor. Attorney Elizabeth Ellison, P 82098 for the plaintiff. Looks like the defendant is here.
Mr. Rogers, your name?
Dale Rogers.
Did you listen to and understand the rights, sir?
I did.
You wish to speak to a lawyer?
No, I don't.
Do you intend to apply for funding?
Not if we can reach our agreement. No.
How much is owed? Just give me the total amount, not a breakdown right now.
$2,244.17.
Can you pay that, sir?
I can pay half by the 14th, and I can have it all paid down to zero by the 19th.
Okay, give me a breakdown on that, please.
Yep, $2,010 in rent, one late fee at $50, the total being $2,060, plus $184.17 in court costs, the balance being $2,244.17. I'm okay just putting the 19th as the writ date, Your Honor.
I'm sorry, say that again? I didn't hear the last line.
The 19th can be the writ date. It doesn't have to.
Okay, so you just pay in full by the 19th. Okay?
Yes, thank you.
That will be the writ date, and the 2244.17 is the amount to be paid to save it, okay?
Okay, thank you.
Good luck to you, sir. Thank you. Mr. Krasinski, do you have a, thanks, Ms. Ellison. Do you have a case in there, Mr. Krasinski? You got to unmute. Tell me if you have a case in this building.
Yes, I do.
Your Honor, he's scheduled for 11:30 as the plaintiff. The defendants have not checked in yet.
Well, they're going to have to wait till this afternoon.
Okay.
Samuel Fitzgerald Holly, 25T645702. Is this Mr. Holly coming in? Are you Mr. Holly?
That is not happening.
He came in for time to pay. The poor guy was waiting. Jennifer, I'm going to just send this down. Maybe somebody can convey to him. I'll just make a note. Defendant in court, waiting for time to pay. He left about 10 minutes ago. Time to pay extended until August. I'm just going to make it September 2nd of 25. People against James Robert Adams. I'll need probation here on this one. 25B823708. I need Emily Tessino.
Okay.
Mr. Mullen, do I have an appearance from you, sir?
I don't know. I think I would if not, Your Honor. I'd be more than happy to fill.
I need you to fill one out if you haven't.
Do you have any blank ones here? Your
Yeah,
Honor?
give him one.
Happy and thank you.
Ms. Foley Carter, your name?
Caitlin Foley Carter.
Mr. Adams, your name?
James Robert Adams.
All right, so you fill that out.
Your Honor, Robert S. Simone on behalf of Mr. Adams, and I'll fill this out right now.
On April 4th of 25, defendant was sentenced. I set a prosecutorial review date. It should have been March 25 of 26. But at any rate, I ordered him to serve 5 days on the court work program and pay $35 per day. I set a beginning August 2nd review date on July the 30th at 8:30. Pursuant to the plea agreement, there was an agreement that the defendant must register and obtain licenses for all animals in the home within 30 days. I also ordered that the dogs remain in the defendant's residence or in a fenced-in yard or on a leash when outside with a lead. This charge of failure to provide proof of animal license was issued on June 30. We were in here July 16th. Mr. Adams said he wanted to hire a lawyer. And that's where we are. So do you wish to have a hearing or do you wish, is he going to plead guilty? Ms. Tessino, your name. Does he wish to hire, does he wish to?
He asked me, Your Honor, just so you know.
No, I know.
I'm asking a different question.
Go ahead. Or does he wish to have a hearing?
What are we pleading to or not pleading to, Your Honor?
Either guilty or not guilty to failure to provide proof of an animal license by May the 4th, which is what I ordered.
Your Honor, he did not have proof of a license by May 4th, but I can give explanation of what was going on.
So is he going to plead guilty or does he wish to have a hearing?
Regarding whether or not May 4th We're just talking about May 4th. I think the court knows, and my client would admit that he did not have a license on that date. But can I say guilty with an explanation?
Well, you're always going to be able to give an explanation.
Well,
if you plead guilty, sir, I want you to understand you could get 5 days in jail on this. Do you understand that?
I do understand.
You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. At a probation violation hearing, you have, why don't you two come on up to the podium if you would, please. At a probation violation hearing, you have the right to remain silent. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and there will not be a hearing. Do you understand that, Mr. Adams? Mr. Adams, do you understand what I just said?
Do you understand what the judge said?
And you wish to plead guilty?
Well, guilty with explanation.
If you plead guilty, I'm taking your plea and I'm going to listen to your explanation anyway.
You will listen to it?
I will listen to it.
Sure, guilty.
To the charge, you failed to obtain proof of an animal license by May the 4th of 25. How do you plead?
Guilty.
Did you fail to provide proof of obtaining an animal license for your dog by May the 4th of 25?
Yes.
Anybody forced you to plead guilty?
No.
Plea is accepted. Have you filled out that and submitted that?
I just want to get the right. I can't remember if it's the city of Woodhaven, the city of.
This is Brownstown. I need your appearance. I will accept the plea. Nobody's forced you to plead guilty, correct, sir?
Correct.
All right. Mr. Mullins.
I have it right here, Your Honor.
I want to remind everybody that you guys signed an agreement to obtain a license from the township. That was on the plea agreement. You can hand that up. That was on the plea agreement. That was what I ordered at the time of sentence. It still has not been done as far as I can tell, unless it's been done in the last 2 weeks. He's got a license?
He does. And Your Honor, look, I understand that whole license and registration. Can I speak now, Your Judge?
Sure.
I don't want to cut anyone before.
Did you, hang on one second. Did you see that license? I did.
I just got it. I think he dropped off on Friday. I was off. So I now have proof that I got it today and I let her know.
And I confirmed with animal control that both dogs are now licensed, Your Honor.
Okay.
Your Honor, this was a troubling situation for Mr. Adams, only in the sense.
If he's got the license, I'm not going to make a big deal.
Okay, I'll shut up, Judge.
I'm not going to, that's all I want. Now, you have to understand, I cannot let a dog that hasn't had rabies shots running around the township. I can't let that go on. I can't let that go on. Even though you're disrespectful from time to time, I have no problem with you personally, Mr. Adams. I really don't. You think differently than I do about the government and all these other things, but I don't have a problem with you personally. But you can't let your dog run all over the township. I've tried to say this nicely 14 times to you and your wife. If you want to let your dogs run, buy all the houses, fence in the yards, get the township to change the zoning. You could have 148 acres. They could all run around. You could have 49 dogs. One of those dogs bites a kid. This is the least of your worries. And these are not little mutts that aren't going to inflict harm. What do you want? What do you want me to do?
Your Honor, as it relates to the license, I have no position now that Mr. Adams has a license, since we were just in compliance.
I know. So was I.
I tried to do the right thing, tried to license him without trying to make sure that he's, just don't want nothing to happen to him.
Nobody wants anybody to happen anything. Dogs, kids.
Yeah, I know.
Adults.
I know. If he was unsafe, I would not even have.
Is he been otherwise compliant as far as you can tell?
Well, there has been, I just got the video to load, that there was, the victim submitted a video, to Caitlin that the dog, one of the dogs, the black one, which was running on his property on July 31st.
Wasn't his.
If I may, Your Honor, they dispute that one or both of those are their dogs. So what I had animal control do, they sent them over to the street to see whose dogs it may have been, and ask the complainant for additional footage to show where those dogs came from. So I don't know if you want to have a separate hearing scheduled for it, in and around animal control to do some legwork on it.
Well, the whole thing would be, did it violate a law, right? So you almost have to, the probation department can issue a show cause for violation of law. You can issue a complaint or a citation for violation of law. And then if that happened, and I'm convinced it's their dog's, his dog.
Just so the court knows, we looked at the photograph as well as the video, and immediately I stated that's not my client's dog. It does not look at all like my client's dog. It looks like a different breed of dog. It's not such a great video that it's discernible, but my client's.
Why didn't he just do this before?
You know, sometimes, Judge, people have different views. And you know what? We're not always saying that they're right or wrong.
You guys signed an agreement and I ordered that the dogs be licensed. And how could they be licensed? In only one way. There's a condition precedent. That is, right? The dog had to have its shots.
Your Honor, can I say this? In looking at the whole issue, we're going to look at this issue with the vaccination. There's a movement now, Your Honor, that vaccination is, now it's not the law. You're not obligated. But I will say this, in looking at this, because now I had to get my nose up in this, the technology that was available at the time, 80 years ago, with the mandatory rabies vaccination law that went through, that we're under our state, they didn't have the ability through measurement and science to do the type of testing that Mr. Adams had requested, which is to be able to draw the blood of the dog, which he did, have its blood analyzed by a veterinarian, which he did, and sign off that there were sufficient antibodies left in the system in order to combat any type of.
Can I ask a question? When did the dog get vaccinated, and has the dog experienced any adverse reactions?
You got on the 31st.
So 4 days ago, any adverse reactions?
He's starting to, he just hasn't eaten. And he, like this morning, he was in sweats.
You can't ask judges just to ignore laws, Mr. Mullen. I mean, it might be that they should, maybe you should call the legislature. You can call the legislature, get them to change the law. But until the legislature changes the law and the township follows suit and changes the law, this is the law.
Your Honor, there have been some communities that have allowed.
That's fine.
They just didn't, they looked at it as community, they decided not to go with it. He got a license.
I don't know how they can, well, whatever. I don't know how they can override state law, municipality, if they think, whatever. I'm not getting into that. Look, he pled guilty. Is there anything else anybody wants to say? I'm going to call this a technical violation. He's going to pay costs of $125. If you object to that, have at it. If he wants to say anything else, have at it. If you want to say anything else, have at it.
I'm not saying.
All right, good enough. Anything else, Mr. Adams?
No, sir.
125. This is not personal. You forced me to bang my gavel twice last time you were in here. You know how many times I hit that gavel? I have law day, and these kids come in and hit it 200 times. I got 300-400 kids that come in here. I've hit it 7 or 8 in 30 years, twice with you here the other day. Knock it off. Good luck.
I did it one time for you, Judge.
You're going to
30 years ago. I'll see you around.
Take care. I need everybody to stay seated.
It's our 11:30.
Mr. Who? What does he have?
These are 11:30. It's
Oh, give me the file. Krasinski?
Yes.
Versus Herndon. Are they here yet, Jen Herndon's?
I have not had him check in on Zoom. I don't know if you want to give him 5 more minutes.
Yeah, I should. I got to give him 5 more minutes, Mr. Krasinski, okay?
Yeah, no worries.
In 5 more minutes, I promise you. Thank you. Stay seated, everybody. What are you guys here on?
We're just watching.
No, we're here for our son. Yeah, here.
Okay.
That's in custody, Judge.
Is that in front of me?
That's one of the traffic custodies.
Okay.
You better talk.
Was subserved on Tyler is what my notes show.
Sir, I'm going to go ahead and adjourn this. I have to adjourn it until the 18th. You better talk to a lawyer. I see you're evicting for non-payment of rent. I don't know the extent of it. I can't give you advice. I can only tell you, you can evict for non-payment of rent if you've sued for non-payment of rent. You're suing for termination of tenancy. So I'd strongly suggest before you come back in a week that you speak to a lawyer. There's nothing more I can go into about it. August the 18th at what time, Jen?
8:30, Your Honor.
8:30. So I'd strongly suggest you talk to a lawyer, sir, before I do it today if you can. Explain what you've done.
I was looking to try to, get on file a negotiation with the tenant. So if they can pay and start
I'm
making.
just telling you, so far from what I see, you're not doing it right.
Okay.
Better talk to a lawyer, okay?
All right. Thank you.
All right, best of luck. See you next week.
All right.
Are you guys here for an arraignment for your son? Is that what it is?
Yes.
I'm not gonna do those till 1 o'clock. We got them all over the city here. We got 5 of them, so, and I got a 1 o'clock docket, so if you want to leave and come back at 1, I'll be ready to go, okay? Thank you. That's what I want to do, Mason.
Okay.
You can get everybody talked to and. Yeah,
I'll take care of it.
I'll serve everybody at 1. Thanks.
Thank you.
And I think Alexa and I will log off for the day.
Yes, I think you guys are good. I was just waiting. Because our 1 o'clock is a return case that has been going on. So.
All right. Well, have a good day.
Yep. We'll see you next week.
Second, the first 3 are 20-year felonies, which is a 10-year. Assault resistant obstructing officer, which is a 2-year. And there's a habitual offense notice, 4th. Does he wish to be formally arraigned or does he stand mute and waive formal reading?
Judge, before we proceed with the arraignment, according to Mr. Gaitan, he's already been sentenced and finished his probation for the fleeing and the resisting charges.
Okay, well, he'll have to talk to the prosecutor or talk to his defense lawyer and let them contend with that. I don't know how that could have happened. Can you pull them up, please?
Then, Judge, then yeah, we'll stand mute.
All right, I'm going to advise you of your rights, Mr. Guyton. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that? Yes. You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. You do not have to speak to the police. If you choose to, you have the right to be represented by a lawyer at that questioning. Again, you have the right to remain silent. You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days there. The probable cause conference, your lawyer will discuss this case with the prosecutor at the preliminary exam. People have to show that the crime was committed and that you committed the crime by a probable cause standard as to each one of these counts. If they prove that as to any one count, you'll be bound over for further proceedings of the circuit court. If they fail to prove that as to any counts, then the counts will be dismissed and you will be discharged. Do you understand that?
Yes.
Probable cause conference will be on August the 12th at 9:45. Preliminary exam will be August 19th at 11:15. That will be in front of Judge Hesson. I'll listen to anything you have to say regarding bonds.
Are you talking to me, Judge, or the?
Yes, sir. Yes.
The detective or myself, Judge?
Oh, you. Whatever you have to say. If I misspoke, my apologies.
Judge, considering Mr. Gaitan's past history, I would say that he's never failed to show up to court, Judge. He's not a flight risk. Regardless of the charges that were pending against him, he's always shown up to court, Judge. Again, like I said earlier, he was under the impression that 2 of the 5 charges had already been dealt with. He does admit that there are the 3 other pending charges, which he's willing to move forward on. With that said, Judge, I would ask the court for a personal bond in this matter, or at least in the alternative, a reasonable bond with a 10% provision.
Did he tell you that he doesn't have any warrants, or did you look at this?
No, Judge, he didn't tell me. I did see that.
He's got all kinds of warrants out for his arrest.
Judge, I believe there was 2 that I saw, if I'm not mistaken, unless I missed something.
Let's see, he's got one out of Dearborn from August 24, 21. He's got another one out of Dearborn, same date. He's got another one out of Romulus, 34th from 23. He's got another one out of Romulus from 23. He's got another one out of 18th and Westland from 25.
Some of them is took care of. They shouldn't even.
Sure. He's got another one out of 35th from 25. He's got another one out of the 35th from 25. He's got another one out of the 35th from 25. Impossible? Well, this was run today. The birthday matches up on all of these.
Can I say something, Your Honor?
I wouldn't say anything if I was you on one right now, sir.
Okay.
Okay, you have the right to remain silent. But I don't know what you're talking about. I don't see any disposition on these cases. Am I missing something, Detective, or did you look at this?
Your Honor, I have not looked at his CCH. If I'm given the opportunity to address bond, sir, face the judge. But I'm given the opportunity to address bond, Your Honor. He has 14 prior felony convictions. This warrant was authorized in late March of this year. He has not been charged with these offenses previously. Given the serious nature of the charges and the fact that he was notified by Detective Sergeant Morrison back in March that he was sent a letter to notify him that these charges were outstanding and he failed to appear or turn himself in. With the severity of the charges, we'd be asking for a cash bond with a GPS tether.
Do you live on Annabelle or Inkster?
Inkster.
Okay. Yeah, I don't know what he's talking about, but these have been adjudicated.
Judge, he said Judge, he said he was sentenced on these back in 22 and get 2 years probation, at least on the counts 4 and 5.
Well, I don't know what happened on the rest of the counts, and I don't know why he doesn't show up in court.
Your Honor, if I may, we were not the only jurisdiction he fled from that day. So he may be referring to cases out of Huron Township. I don't know with any certainty on that, but I do know that he fled from another jurisdiction on the same day.
I'm going to give you your bond conditions, sir. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. You're to attend AANA at least 4 times a week. Give them a form, will you? That has to be in person, sir. You have to go in person. Every time you go, you have to have the form signed. Every time you come to court, you have to have the form with you. You do have to test weekly, so you'll see probation. You have to test weekly. You're required to obtain a tether. You're not to be released until fitted with a GPS tether. He has a multitude of warrants. $150,000, 10% is your bond. You're gonna have to post $15,000. Your next court date will be August 12th at 9:45. Don't shake your head. Okay? Show up in court. Do not shake your head at me, Mr. Guyton. You understand what I'm telling you, son?
Yes, I understand.
Good. Good luck.
Thank you, Your Honor. Thank you.
For who? I'm sorry? Trollinger. Kiss Trollinger. 25B74545. Detective.
Good afternoon again, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
Raise your right hand and solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do.
Okay, go ahead.
Your Honor, as a preliminary matter, I would note for the court that the dates are incorrect under the third offense notice. The first date that's listed is November 12th of 2003. That should be February 9th of 2004 out of the 14A2 District Court. And then the second date, which is listed as 12/21 of 97 out of the first District Court, should be February 18th of 1998.
All right, I'm changing to both the complaint and warrant. I'm initialing the changes. You can go ahead and proceed.
Thank you, Your Honor. On June 2nd of 2025 at approximately 5:18 p.m., Officer Walker was dispatched to the intersection of King Road and Allen Road in Brownstown Township in reference to a traffic crash that had just occurred at that location. Upon arrival, Officer Walker observed that there were 2 vehicles involved, a blue Nissan Frontier pickup truck and a silver Ford Fusion sedan. Officer Walker first made contact with Mr. Austin New. Mr. New was the driver of the Ford Fusion and stated that he was turning left from southbound Allen onto eastbound King Road with a green turn light. Mr. New stated that the Nissan Frontier was northbound Allen Road south of King Road, failed to stop at the red light and struck his vehicle. Officer Walker also spoke to a witness, Jenna Pascarella. Ms. Pascarella stated that she was stopped at the light at westbound King at Allen Road and witnessed the crash. Specifically, she stated that she observed the Ford Fusion turning left from southbound Allen onto eastbound King when the Nissan Frontier, which was traveling northbound on Allen, entered the intersection and struck the Ford Fusion. Witness Pascarella said she was not sure the status of the traffic signal, but based on her position, she estimated that the light for eastbound and westbound King Road turned green approximately 3 seconds after the crash. She also stated that after the crash, she made contact with the driver of the Nissan Frontier, Mr. Kish Trollinger. Ms. Pasquarella stated that defendant Trollinger was the only person in the Nissan Frontier and was seated in the driver's seat. Ms. Pasquarella stated that when she asked Mr. Trollinger if he was okay, he stated yes, and then immediately told her that he had been drinking. Officer Walker subsequently made contact with Mr. Trollinger, identified by his Michigan driver's license. At that time, Officer Walker noticed the odor of intoxicants coming from Mr. Trollinger's breath and person, and observed that his eyes were watery and bloodshot, that he was unsteady on his feet, and that he had poor coordination and slurred speech. Mr. Trollinger stated that he was driving the Nissan Frontier northbound on Allen Road through King Road when another vehicle turned in front of him, causing him to strike that vehicle. Mr. Trollinger stated that he had a green light. Mr. Trollinger admitted that he consumed 2 24-ounce Ice House alcoholic beverages 3 hours before the crash and denied consuming any other intoxicants. Based on his observations and Mr. Trollinger's admissions, Officer Walker requested that, Mr. Trollinger complete SFSTs. During the medical questions, Mr. Trollinger informed Officer Walker that he is a type 1 diabetic and has high blood pressure, but refused medical evaluation or assistance, and Officer Walker proceeded to attempt to administer SFSTs. Officer Walker attempted to first administer the HGN test, but Mr. Trollinger would not follow Officer Walker's finger or Officer Walker's instructions and could not complete the test. Officer Walker next began the instructional phase of the walk and turn, but Mr. Trollinger stated that he was dizzy due to high blood pressure. Officer Walker requested he sit down and offered medical treatment again, but defendant Trollinger refused to sit or accept medical treatment. As a result of defendant Trollinger's complaints and unwillingness to follow Officer Walker's directions, the walk and turn test was terminated, and Officer Walker did not attempt to have him perform the one-leg stand. The final test Officer Walker attempted to administer was a counting backwards test. He instructed Mr. Trollinger to count backwards at 93 and stop at 82. Mr. Trollinger counted backwards from 93 to 83, but failed to stop at 82 as directed. Officer Walker administered a preliminary breath test on Mr. Trollinger that showed the result was a BRAC of 0.201. Officer Walker placed Mr. Trollinger in arrest for operating while intoxicated and obtained a search warrant for Mr. Trollinger's blood, which was authorized by the Honorable Judge Coleman Hudson of the 33rd District Court. Mr. Trollinger was subsequently transported to Henry Ford Brownstown, where his blood was drawn by a registered nurse pursuant to the guidelines of the MSP blood kit. Mr. Trollinger and the MSP blood kit were transported back to the Brownstown Police Department, where Mr. Trollinger was book processed and the blood kit was placed in the outgoing secured mail bin. On June 16th of 2025, I received the first toxicological result for Mr. Trollinger's blood, which showed that his blood alcohol content at the time of this event was 0.164 grams of alcohol per 100 milliliters of blood. There was one additional test still pending, but it showed no other substances in his system. A check of Mr. Trollinger's CCH and Secretary of State records show that Mr. Trollinger has at least 2 prior misdemeanor alcohol-related convictions. The first on February 18th of 1998 for operating while impaired by liquor, which he pled guilty to out of the 1st District Court in Monroe. And then on February 19th of 2004, when he pled guilty to operating while impaired by liquor out of the 14A2 District Court in Ypsilanti.
Is that February 19th, you said?
Yes.
Thank you. Based on your sworn testimony.
I'm sorry, Your Honor, February 9th, not 19th. My apologies.
Sure, hang on. I need some more. Based on your sworn testimony, I find the crime of OWI 3 was committed. There's probable cause to believe the crime was committed by the defendant. I'm going to authorize the issuance of the complaint warrant. Again, I've initialed the changes, and I'm issuing the warrant for the arrest of the defendant. You're all set on that? You don't have any others, right?
I do not. Detective Platt has read a record that gets submitted. I don't know if they received it and processed that yet. He's standing by here if you were ready for that one as well.
Let's just came in.
Gary Wayne, okay, I'm gonna go on to Trenton's here. So as soon as I get it, we'll call, but I got a civil case here I gotta deal with. Gary Wayne, 5T718-253. Your name?
Detective Sergeant Mark Driscoll, Trent Police.
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth self you got.
Yes, Judge.
Okay, go ahead.
On August 1st, 2025, at approximately 22:50 hours, Trent Police Officer Blake Rusnick was on patrol in the area of West Road and Chelsea Street in the city of Trenton, County of Wayne. Officer Rusnick observed a black 2025 Pontiac Grand Prix bearing Michigan license plate Edward William 4891, which showed registered to Gary Wayne Begley, date of birth of 2/28/75. Officer Rusnick observed the vehicle have a broken driver's side taillight, which was emitting white light. Officer Rusnick activated his emergency light and attempted to make a traffic stop, which the vehicle initially began to stop at West and Edgemont. The driver then accelerated the vehicle westbound West Road and continued westbound, increasing its speed, at which time Officer Lippa arrived to assist with the pursuit. Officers continued to pursue with their emergency lights and sirens activated, the vehicle which continued to flee onto northbound I-75. The vehicle continued on northbound I-75, exceeding speeds in excess of 100 miles an hour in a 70-mile-an-hour zone. Additionally, Sergeant Nathan Pugh informed officers that Mr. Begley had active warrants for controlled substance. Officers continued to pursue northbound 75, where they observed the vehicle exit eastbound Dearborn Street in the city of Detroit. Officer Lippa, who never lost sight of the vehicle, continued to pursue the vehicle at a high rate of speed through residential streets when he observed the vehicle stop in front of 9217 Longworth in the city of Detroit. Officer Lippa observed a white male, later identified as Mr. Begley, exit the driver's side, flee into the backyard. Officer Lippa gave Mr. Begley verbal commands to stop, which he complied and was arrested. The vehicle was impounded and transported to the Trenton Police Storage Garage by Lions Towing. Officer Rusnick and Officer Brendan Honeycutt inventoried the vehicle per the Trenton Police impounded vehicle policy. Officer Rusnick located a red handled Milwaukee double-edged fixed blade knife between the driver's seat and center console. Officer Rusnick located a powdery white substance which appeared to be cocaine. Officer Rusnick field tested the suspected cocaine utilizing the mobile detect multi-drug test kit, which revealed a positive for cocaine. Officer Rusnick also weighed the suspected cocaine, which revealed 0.1 grams with container. That's it, Your Honor.
You need the fourth offense notice. You got these June 29/95. All content to great bodily harm. September 9 of 96, possession of analogs, Detroit Recorder's Court. January 26/06, possession of a controlled substance, Oakland County Circuit Court. Can you?
You are correct, John. I did see Mr. Bagley's CCH and was able to confirm those prior convictions.
Ask you a question. Where was he going in Trenton? What street when the speed limit was 35 miles per hour or less?
He was heading down West Road. At that point, between Chelsea and Longmeadow, he exceeded speeds of over 10 miles an hour with officers pursuing with lights and sirens on.
Okay. And right there, the speed limit's 35 miles per hour or less, correct?
Correct, Your Honor.
Based on your sworn testimony, I find that the crimes of Plaintiff allude third, possession of cocaine, reckless driving with habitual fourth were committed. There's probable cause to believe those crimes were committed by the defendant and unauthorized. The issuance of the complaint and the warrant. I'll note that you signed the complaint, court is signing and dating the complaint and the warrant for the arrest of the defendant.
Thank you, Judge.
Who else do you have over here? He's not
Mr.
Begley.
No, he ended up subsequently getting admitted to the hospital, Your Honor. He was released to the hospital.
Okay, are you ready on Dion Harris?
I am, Judge.
Okay, let's do that one. Dion Deshaun Harris, Jr., 25T718-236FY. Mr. Gaith, I'll be handling this in a minute as soon as I do the sign on record. Detective, your name?
Detective Sergeant Mark Driscoll, Trenton Police.
Raise your right hand. Solemnly swear or affirm under penalties of perjury that the testimony you give in these proceedings will be the whole true self you got.
Yes, Your Honor.
Okay, go ahead.
On August 1st, 2025, at approximately 14:32 hours, Trenton police officers were dispatched to 2760 West Jefferson Avenue, which is a Roundhouse Barbecue restaurant in the city of Trenton, County of Wayne, for a fraud complaint. Trenton Police Dispatch broadcasted that the manager, a Miss Brittany Wheeler, had two subjects later identified as Dion Deshaun Harris Jr., date of birth of 4/17/00, and Alyssa May, I'm going to spell it, Judge, Palicz, date of birth of 3/24/01, who had used a stolen credit card to purchase a gift card, and they were still at the location. Officer Stephen K. and Officer Kenneth Galez arrived and spoke with Miss Wheeler, who explained earlier she received a phone call from 248-419-5290. Ms. Wheeler stated the caller identified himself as Mr. Harris's grandfather and that he wanted to upload $250 onto a gift card for his grandson. Ms. Wheeler stated the caller stated Mr. Harris would be coming to the restaurant to eat and would claim the gift card there. Ms. Wheeler stated that the caller provided a credit card number and the transaction was processed. Ms. Wheeler stated that a short time later, she received another call from the victim, Mr. Stephen Kim, who stated someone had fraudulently used his Chase credit card at the location. Ms. Wheeler stated at approximately 14:50 hours, Mr. Harris, along with Ms. Palicz, came to the hostess area and provided his name and requested the gift card. Ms. Wheeler recognized the voice as the same as the caller who stated he was Mr. Harris's grandfather. Officer Claus made contact and requested I check the subscriber's information for that phone number that called the restaurant, which is 248-419-5290, which revealed it was an envoy, a voice over internet with no listed subscriber. I called the number from a Trenton police phone, which Officer Claus reserved a call on Mr. Harris's phone caller ID from the Trenton police. Mr. Harris was arrested and transported to the Trenton police. I spoke to Mr. Kim, who stated that the credit card fraudulently used was his Chase card ending with 3529. Mr. Kim subsequently provided an online statement showing the charge had been approved. Mr. Kim stated he did not authorize anyone to use that card. I escorted Mr. Harris to the Detective Bureau interview room with Officer K. I read verbatim Mr. Harris's Miranda rights from the Trenton Police Miranda rights form. Mr. Harris agreed to waive his rights, signed the form, and agreed to speak with us. Mr. Harris stated he did call the restaurant using the envoy number, and he did speak with the manager. Mr. Harris stated he obtained the credit card numbers through an app, Your Honor.
All right, based on your sworn testimony, I find the crime, the illegal sale of the financial protection device was committed. There's probable cause to believe the crime was committed by the defendant. I'm going to authorize the issuance of the complaint and the warrant for the arrest. Sign the complaint. I've also signed the warrant. Mr. Gates, your name?
Good afternoon, Judge Magnus Gates, appearing on behalf of Mr. Harris.
Mr. Harris, your name?
Dion Harris.
All right. Detective, your name again?
Detective Sergeant Mark Driscoll, Trenton Police.
For purposes of arraignment, how does he wish to proceed?
We'll stand mute and waive reading, Judge.
I'm going to need another bond sheet. I'm sorry, I screwed that up. All right, Mr. Harris, I'm going to advise you of your rights. You have the right to remain silent. You do not have to say anything. If you do say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. If you cannot afford one, you can apply for one at public expense. Also, if you choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes, sir.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. At the probable cause conference, your lawyer will discuss this case with the prosecutor. At the preliminary examination, the people have to show that the crime was committed and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings to the Wayne County Circuit Court. If they fail to prove that, the case would be dismissed and you would be discharged. Do you understand that, sir?
Yes, sir.
All right, probable cause conference will be August 12th, 9:15. Preliminary exam will be August 19th at 11:15. Those will be in front of Judge Hudson, August 12, 9:15, August 19 at 11:15. He has a couple warrants. Mr. Gates, what would you like to say?
Judge, we're asking for a personal bond in this matter. Mr. Harris is 25 years old. He does own his own business. He's owned his own business for the last 3 years. He has no prior criminal record, Judge, other than the pending charges. I don't believe he's a flight risk, Judge, or a danger to the community. Otherwise, other than these charges, Judge, I mean, he's never gotten in trouble before. With regard to the warrants, I know that Mr. Harris does share a name in common with his father. So he believes that at least the Livonia warrant is not his, and that may have something to do with his.
That looks to be the case. He has one out of Highland Park.
He does admit to that one, Judge. He's going to.
Does he live on South Annabelle?
Yes, Judge.
Yes, sir.
What are you asking for, Detective?
Judge, we leave it to your discretion.
Look, I'll give you a personal bond. Don't make this worse than it is, okay? Do not make this worse than it is. You'll live to regret that. $7,500 personal. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No contact with Steve Kim or Brittany Wheeler. No contact with prosecution witnesses except through your lawyer. You're not to enter the property address or go near 2760 West Jefferson in Trenton. Again, you can't leave the state, can't violate a law. You must appear in court as directed. You'll get yourself a lawyer, and you will be here on August the 12th. Okay, sir, do you understand that?
Yes, sir.
Do you have any questions?
No, sir.
All right, best of luck. Thanks, gentlemen. Thank you.
Thanks, Judge.
Right out there. Cody Allen Riska, 25F 705-403-FY. Your name?
Good morning, Your Honor. Detective Lieutenant Chris Rembez, City of Flat Rock Police Department.
Known to you. Raise your right hand. Solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
Yes, I do.
Okay, go ahead.
Your Honor, on 11/30.